Good morning. This meeting will come to order. This is a public meeting of the Commodity Futures Trading Commission to consider issuance of a proposed rulemaking under the Dodd-Frank Wall Street Reform and Consumer Protection Act regarding four proposed rules. These proposed rules relate to product definitions, which is a joint rule with the Securities and Exchange Commission. They relate to segregation of customer collateral for cleared swaps, those swaps taken to a clearinghouse. Capital requirements for non-bank swap dealers and major swap participants. And then some conforming amendments to certain CFTC regulations, as we've done at least twice during this proposed rulemaking phase. In addition, the Commission will consider aligning the comment period on the margin rule that was proposed on April 12th, and this is to align that rule with the capital rule. I'd like to welcome members of the public, market participants, and members of the media to today's meeting, as well as welcome those listening to the meeting on the phone or watching to the live webcast. We look forward to receiving public comments on the proposed rules we're considering today, and the rules, as well as fact sheets and Q&As and documents, will all be posted on our website shortly, as we've done in our prior meetings. This is the 14th meeting, actually, as we consider Dodd-Frank rulemakings. And at this point, as we consider these four rules and hopefully share them with the public with the Commission's support, we will have substantially completed the proposal phase of our rule writing to implement the Dodd-Frank Act. And so I want to take this opportunity and thank the staff for their extraordinary work. I think this is 40 weeks since the President signed the bill. They're probably counting, the staff, but it's just remarkable work with good humor and thoughtfulness to comply with congressional intent and the law, to take hundreds of meetings, in fact, between regulators and the public, probably over 1,000 meetings, and they've started to review what is now tens of thousands of comments. Similarly, I want to thank Commissioner Mike Dunn and Commissioner Jill Summers, Bart Chilton, and Scott O'Malley for all of their hard work during this process. The commissioners and their very able staff have diligently evaluated all of these staff proposals, provided insightful comments throughout, I think made the rules better for the public. Since the President signed the Act, the Commission has promulgated rules and will, with today, covering all of the areas set out in the Act for swap regulation, with the exception of the Volcker Rule, which the Act itself set a different timeline for. With the substantial completion of the proposed phase this proposal phase of the rule writing, the public now has the opportunity to review the whole mosaic of rules. This will allow the market and all the market participants to evaluate the entire regulatory scheme as a whole. And to further facilitate this process, this morning we'll consider possibly reopening or extending the comment periods for most of the Dodd-Frank proposed rules for an additional 30 days. Specifically for rules where the comment period had closed, the comment period would be reopened for 30 days, or if it's about to close, it would at least be extended so that the total would be 30 days. This time will allow the public to submit any comments they might have after seeing the entire mosaic, and as part of this, I'm hopeful the market participants will continue to comment about potential compliance costs as well as the phasing and implementation dates with regard to these rules. One opportunity, actually, a very key opportunity to comment will be next week. This SEC and CFTC staffs will have a two-day roundtable to hear from the public on the best schedule of implementation dates for effective dates of these final rules. We've also opened a few weeks ago a public comment file which is open, I think, through June 10th or so on some of these implementation and effective date processes. Before we hear from staff on these four rules that we'll consider today, I'd like to recognize my fellow commissioners. I believe that Commissioner Don, I don't see the camera, and Commissioner Chilton are together in Chicago. So Commissioner Dunn.
Thank you, Mr. Chairman, and I want to thank all the folks joining us today for this important meeting regarding the implementation of the Dodd-Frank Act. Today, as we near the end of our meetings regarding proposed rule, we will finally consider our product definitions rule, a joint rule with the SEC, which, in a perfect world, would have been one of the first rules proposed because meaningful input from those who will be under the new regulatory regime depends upon knowing precisely what constitutes a swap and what does not. We will also discuss our conforming rules, whose purpose is, in part, to ensure that what is required for swaps is required for futures and vice versa. In a perfect world, conforming rules would be the last proposed and finalized. To do them correctly depends on having a view of all of the other rules. However, this is not a perfect world. And the Commission and its staff is doing what it can, when it can, with the resources we have. And, Mr. Chairman, I join you in saluting the staff for doing an outstanding job. In considering the proposed rule for capital requirements for swap dealers and major swap participants, I will be particularly interested in hearing staff's thoughts on the public comments on how much this rule will cost not only the industry, but the CFTC. I believe this rule is a necessity, but I'm interested to hear if or how these proposed requirements will affect the cost of transacting swaps. At the very least, the proposed capital rules will increase the burden on current Commission staff and will require the hiring of additional staff. I'm also very interested in hearing the public comments regarding the proposed rule on protection of cleared swap, customer contracts, and collateral. While staff makes specific recommendations today regarding the approach that the Commission should take, the proposed rule also lays out a number of alternatives that staff has considered. I look forward to reading the comments on this rule so that the Commission determine the best approach. As we move from the process of proposing rules to the process of final rules, I will rely heavily on the comments we receive from the public in forming my opinion on the final rules. While I have specific questions regarding each final rule, there are two broad themes of questions that I have for each of the final rule teams. First, how can the rule be made more principle-based and less prescriptive or restrictive? And second, how much will the rule cost the Commission to implement, maintain, and enforce, particularly in terms of staffing? I have provided a series of questions regarding these themes to the rule teams and will look forward to the answers to those questions as we move to the final rules. I would like to once again thank the staff of the CFTC for all their hard work on these very important proposed rule, and I look forward to their presentations.
Thank you, Commissioner Chilton. Commissioner Summers.
Thank you, Mr. Chairman. And I want to thank all the teams that are here today for all of the hard work that they've put in on the proposals that we're considering today. As all of you know, a number of these proposals today are linchpins in the new regulatory structure that we are creating, and I know that the public, end users, and members of Congress have been anxiously awaiting these proposals. Before moving to the specific proposals before us today, I would like to focus on the Dodd-Frank repeal of certain provisions of the Commodity Exchange Act that were added by the Commodity Futures Modernization Act of 2000 to provide legal certainty for over-the-counter markets, namely 2D, 2E, 2G, 2H, and 5D. These provisions will be rescinded on July 16th, less than 3 months from now, even though the new regulatory framework for trading and clearing swaps will most certainly not be operational by that date. Last September, the Commission issued an order outlining a process for grandfather relief for exempt commercial markets operating pursuant to 2H3 and exempt Board of Trade operating pursuant to Section 5D. The Commission order is in order to be entitled grandfather relief, among other things, the ECMs or to be entitled, the ECMs or EBOTs must have filed a CEF or DCM application within 60 days after the effective date of final regulations implementing Sections 733 or 734 of Dodd-Frank, and the CEF or DCM application must be currently pending before the Commission. The wording of these requirements clearly presumed that final regulations implementing Sections 733 and 734 would be issued before July 16th and may not make sense in the absence of final regulations. I believe the Commission should readdress its order to ensure that it provides market participants with sufficient certainty as to the status of ECMs and EBOTs on July 16th or thereafter, particularly in light of the fact that it will likely be impossible for an ECM or EBOT to have a CEF application currently pending on July 16th. At the same time, the Commission issued its order outlining a process for granting grandfather relief to ECMs and EBOTs. The Commission declined to grant grandfather relief to market participants transacting swaps in reliance of Section 2H1 and said nothing about Sections 2D, 2E, and 2G. With the Dodd-Frank effective date looming and no grandfather relief or no action relief process yet announced for market participants transacting in reliance on these critical provisions, the level of uncertainty in these markets is mounting. Again, I think it is imperative that the Commission publicly announce as soon as possible how it intends to address the legal uncertainty that will be reintroduced into the OTC swaps market on July 16th when the Section 2 provisions are repealed and the certainty provided by the CFMA goes away. It is my hope that the Commission will issue specific guidance to market participants as soon as possible to clarify for them what happens in these markets on Monday, July 18th. I would also like to discuss the next phase for us in the rulemaking process. Although I completely understand interested parties' anxiety regarding the implementation phase or the staggering of effective dates for final rules, I am actually more concerned with our internal process for moving forward with issuing final rules. The process for issuing proposed rules was rushed, and in my view, it was guided by meeting the tight deadlines that were set by the statute. There was often insufficient time for us to fully consider the implications of all aspects of some of the proposals, particularly when we were getting revisions the night before the vote and sometimes on the morning of a vote. I would have preferred that the Commission spend more time on many of the proposals to get them in the state as close to final as possible. We often did not do that. On the contrary, we have issued a number of proposals in which at least 3 commissioners have voiced concerns regarding the possibility of unintended consequences. While there is room for error when issuing proposed rules, there is no room for error when issuing final rules, which is why I believe our internal process for finalizing rules is vitally important. We must ensure that we have sufficient time to analyze each and every rule, that final rules changed at the last minute are not called up for a vote, and that we set a meeting schedule that allows sufficient time between meetings for serious internal consideration by all of us of the views of staff, the views of the commenters, and most importantly, the views of each other. I am, of course, looking forward to the guidance from the Joint Roundtable next week on implementation, but I also look forward to finalizing the specific process we will operate under internally to make sure that we move forward in an orderly fashion, guided by policy and not by deadlines. Finally, before I address the proposals before us today, I would like to say that I wholeheartedly agree to us extending or reopening the comment periods for most of the proposals that we have issued. However, I'm objecting to this today since I did not receive it until late last night and haven't had the chance to look at it. Given the number of proposals and the complexity of the proposals that we are reopening, I also question whether 30 days is sufficient time to comment on over 32 different releases. And finally, to the agenda before us today, I think it represents an enormous effort on the part of our staff and the work that they have put into the giant stack of paper that we have in front of us. While I have a number of concerns with regard to these proposals, my votes in no way express dissatisfaction with the quality of work that's been done to get these proposals ready for today's vote. On the product definitions proposal, obviously I'm pleased that we're finally able to get to this critical proposal. But as been my practice throughout the rulemaking process, I have voted against proposals that I thought were over-reading our mandate or simply overreaching. I think that the proposed anti-evasion provisions within this document do just that. I agree that Section 721C directs the Commission to modify certain definitions to include products or entities that may be structured to evade the requirements of Dodd-Frank. However, I don't agree that being directed to modify definitions equates being directed to propose broad anti-evasion provisions, and I think it's an overreach. I'm also troubled that this proposal does not discuss issues raised by multilateral development institutions in which the United States is a member, such as the World Bank, the Bank of International Settlements, the International Bank for Reconstruction and Development, and the International Finance Corporation, among others that have come to us with very specific concerns. All of these organizations share the same fundamental mission, which is to provide economic development and reduce poverty in developing countries, and I do not believe that they should be included in the proposal that we have before us. The draft that I received 2 weeks ago included a discussion of their issues and contained a number of questions for the public to comment on. All of that has been omitted in the document before us today, and I think that is a mistake. These entities have legitimate issues, and I do not see the harm in highlighting them and asking questions. I don't recall us highlighting their issues in any other proposals, so I question why not include them in this proposal. Not raising the issues at all because we think the entities will comment anyway may not cause others that are directly impacted with help that are not directly impacted, but with helpful information that may want to comment on these issues. As a result, in my dissenting statement on this specific proposal, I will include the discussion and questions as written by staff that they provided in their earlier draft, and I hope that the public will take the opportunity to comment. With regard to the segregation and bankruptcy proposal, I have a number of reservations because I think it mistakenly fails to retain sufficient optionality for FCMs and DCOs to implement different models based upon the needs of their customers. The proposal clearly favors adopting the complete legal segregation model as providing the best balance between benefits and costs. I'm not convinced of that, and I welcome comments on the bankruptcy rules and other issues surrounding optionality. I also believe that the contrast between sections 4DB and 4DF6 of the CEA, namely the use of the terms customer versus customers, is suggestive of nothing more than a drafting error. Finally, I also have strong objections to including two important substantive provisions within the conforming amendments today, one governing bunched orders and the other one requiring new duties with respect to creating and maintaining audio files of all oral communications leading to the execution of a transaction in a commodity interest or cash commodity. I believe these significant issues should be addressed separately and do not belong in a conforming amendments document. I encourage the public to read these conforming amendments very closely and to comment as appropriate. Again, I want to thank all of the teams for their hard work today on these very significant proposals, and I look forward to hearing your presentations.
Thank you, Commissioner Summers. Commissioner Chilton, back to Chicago.
Thanks, Mr. Chairman. I actually agree with Commissioner Summers on a few things, but I diverge at one point here, maybe a couple of points. You know, I don't think that it was possible for us to get these rules right immediately out of the gate. Some of them we had a very steep learning curve on, and the reason that we put them out, in my view, is that we needed to get comments to further fine-tune the rule. I agree with her that it's really the final rules where the rubber meets the road, and Commissioner Dunn's talked about that also, that we need to get it right, and we will. And as the chairman said, we're not going to get things done on time as Congress suggested. So I think we are going to be deliberate. I think we have been deliberate. I think this effort that the chairman's put forward for an additional 30 days on some selected rules, and I want to ask some questions about that later, but I think that's a good effort. And but I do get concerned, and I want to make sure I'm specifically not talking about Commissioner Summers or anybody else at the CFTC. I think the deadlines that Congress passed are important deadlines for us. I think that the urgency that existed last year when Congress passed the bill and the President signed it, that urgency exists still today. And that there are dangers out there in the OTC world that we've got to get a handle on with these rules and regulations. But obviously we want to do them right. But I think there are some out there that want to sort of run out the clock. And again, I'm not talking about anybody in this meeting or at the CFTC, but I think some, and many of these people are folks who oppose the bill to begin with, really want to run it out until maybe after the next presidential election. Maybe consumers will not be as hot on financial reform then. And I think that would be a mistake. So I know my colleagues and I, all of us want to do what we believe is the right thing, but we want to be deliberate about it. And I respect that. And I think we'll get there. We may need some pushing from the outside once in a while, and that's all well and good. But we need to be thinking about these things as we go forward. Thank you, Mr. Chairman.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you, Mr. Chairman, and let me thank the teams who have spent many, many long hours negotiating and developing the rule proposals before us today. Greatly appreciate your hard work and being on the front line of negotiations. Let me begin by making a comment on the rulemaking process going forward. After the May 2nd and May 3rd staff roundtables on the implementation process, it is my hope that the Commission will release a comprehensive schedule of the sequencing of final rulemakings and a proposed implementation plan of to be put in the Federal Register to allow public comment on it before we finalize the rules under Dodd-Frank. Like you, Mr. Chairman, I believe transparency will benefit this process by allowing the public to comment on both the sequencing of the final rules and the proposed implementation plan. Those affected by the rules will have the transparency and certainty they will need to make budget, investment, and staffing decisions. Now, let me turn to the proposed rulemakings. After almost 10 months, the products rule that will define the definition of a swap is finally before us. I think the public will be surprised that this rulemaking is over 300 pages in length and by the number of differences that still exist between the two commissions with respect to insurance products, foreign sovereign debt instruments, and swap indexes. I have a particular concern about the anti-evasion proposal and how the Commission will conduct its analysis and implement this provision going forward. While I believe our implementation of the forward exclusion is consistent with the years of Commission practice, I would like to hear from the public whether it will allow the forward market to continue to operate under Dodd-Frank in the same manner as it does today. With regard to the financial transmission rights in electricity markets, this proposal recommends the Commission use the public interest waiver authority provided under 722F of the Dodd-Frank Act, and I believe that is the appropriate process. As I was reviewing the treatment of single-name CDS and index credit default swaps in the proposal, it struck me that the market participants who purchase these products will not be able to margin them on a portfolio basis. Congress gave the SEC and the CFTC a mandate under Section 713 of the Dodd-Frank Act to propose a joint rule on portfolio margining. Unfortunately, we are now at the end of the proposed rulemaking process, and we have not proposed a portfolio margining rule. Portfolio margining is a non-controversial, and the entire market wants it, and it is one of the few, if not the only, cost savings tools in the entire Title VII. Now let me turn to the capital rule. let me first say that I strongly believe that swap dealers must be adequately capitalized. A swap dealer with enough regulatory capital to stand behind a trade gives the comfort to counterparties. While I realize that undercapitalized financial institutions were at the heart of the financial crisis, I want to point out that commercial entities that use swaps were not the root of the problem, and this proposal seems to ignore the flexibility of the statute and the congressional direction as it relates to the application of capital charges on end users. With that said, I want to read the language of Section 731 of the Dodd-Frank Act, which states, quote, to offset the greater risk to swap dealer in the financial system, capital requirements for uncleared swaps shall be appropriate for the risk associated with the non-cleared swap held by the swap dealer or major swap participant, end quote. I cite this language because I don't feel the proposal gives enough consideration to the phrase, quote, as appropriate for the risk. In particular, non-bank, non-FCM swap dealers will be required to calculate and hold capital for each and every swap they enter into with a commercial end user, beginning with the first dollar of exposure. This regulation provides no thresholds, no exemptions, and certainly no consideration of the statutory flexibility in the Dodd-Frank Act. Just so we're clear, commercial end users are cooperatives, captive finance companies, farmers, municipalities, and other non-financial, non-systemically risky counterparties. If a commercial swap dealer does not collect margin from the commercial end user, then it must take a capital charge equal to its credit risk exposure to the end user and the market risk of the swap. Two outcomes will result from this regulation. Either the swap dealer will require commercial end users to post margin to avoid taking a capital charge, or they will point to the regulation as a reason to increase the bid-ask spread of swaps for end users to cover the capital charge mandated by this rule. Either way, the cost of hedging commercial risk for end users is going up. What I've described is contrary to the intent of Congress. I quoted from the Lincoln Dodd letter in the last meeting, but I feel compelled to do it again. It says that, quote, Congress clearly stated in this bill that the margin and capital requirements are not to be imposed on end users, end quote. The letter goes on to say that the capital, quote, the capital and margin standards should be set to mitigate risk in our financial system, not punish those who are hedging their own commercial risk, end quote. Our proposed capital rule does just that. As a result, I will not support this proposal. Another concern I have is with the impact this rule will have on non-bank, non-FCM commercial firms that are likely to be captured by the overly broad definition of swap dealer proposed by the Commission. A non-bank, non-FCM swap dealer is an entity that generates the overwhelming majority of its income from commercial activities and engages in de minimis dealing activities. I predict this capital rule, combined with a broad swap dealer definition, will drive commercial firms that pose little, if any, systemic risk to the financial system out of the market-making business and concentrate the swap dealing business with the Wall Street banks. Higher costs and less competition for commercial end users is not a proposition I favor, especially when I consider the source of the financial contagion in 2008. Because the Commission put forward a swap dealer rulemaking in December 2010, long before the capital and margin rules were completed, the swap dealer team did not have the benefit of comparing the cost impact of the broad swap dealer definition with the margin and capital rules proposed in the last two meetings. I also believe that the recently released CFTC Inspector General report on cost-benefit analysis has appropriately highlighted the lack of attention that was paid to the assessing the true cost of the swap dealer rule in the first place. The agency needs to take that report very seriously. I'm in favor of a complete reproposal of the swap dealer definition rule. The reproposal must narrow the definition of a swap dealer and perform a more rigorous analysis of the costs of the rulemaking to both the market and the Commission. Finally, let me turn to individual segregation. As my colleagues have noted, this is a complicated issue, and how cleared customer collateral should be segregated, and this was a significant debate back in December. After receiving several comments on the proposal, the Commission has narrowed its options by eliminating the complete physical segregation model from consideration. The current proposal leans towards adopting a complete legal segregation model. To get this issue right, though, I believe we need to continue to consider other options that are viable alternatives and let the market decide which model best balances higher operational costs against the benefit of increased levels of consumer collateral protection. As a result, I've asked the team to consider the current futures model as well, and this proposal signals in its preamble that the Commission is still considering that alternative. I recognize, though, that the futures model represents certain challenges to fellow customers of an FCM who don't currently have the benefit of knowing enough about the risk profile of their fellow FCM customers. I'm particularly interested in comments regarding how we might address that challenge, including requiring certain disclosures by FCMs. I'm pleased to see that the preamble reflects the strong debate inside the Commission on the effect of each option under the Bankruptcy Code as well. Finally, I'm pleased that the preamble of this proposal includes language that will allow the Commission to adopt a final rule which lets a DCO choose which model is right for its business. I believe this flexibility allows the market to determine which option is the best way to move forward in the cleared swaps world. All in all, I recognize the hard work of the teams and greatly appreciate their efforts in putting these extensive and very detailed rules together. Thank you.
Thank you, Commissioner Mallia. Thank you all of my fellow commissioners. And I think now the staff will present their proposals and recommendations to Commission. After each of these presentations, the floor will be open for questions and comments from each of the commissioners, and then following that, we'll take a vote. To that end, let's see. I think I've already done this, but it says I'm supposed to ask for unanimous consent that final votes on the proposed rules be done by recorded vote and that be put in the Federal Register. I thought we did that already always, but in case I hadn't. Not hearing any objections, we'll do this by recorded votes. So then I'm going to turn to this team that's been working with the Securities and Exchange Commission on further defining swap, securities-based swap agreement, and the regulation of mixed swaps, as the Dodd-Frank was very specific on these matters, but asked the SEC and CFTC to jointly give further clarification. Dan Berkovitz, our General Counsel, and with him Terry Arbit, Julian Hammer, and David Aaron from the Office of General Counsel. The floor is yours.
Good morning. This rulemaking proposal and interpretive guidance, which is being proposed jointly with the SEC, further defines the terms swap, security-based swap, and security-based swap agreement, provides for the regulation of mixed swaps, and addresses books and records requirements for security-based swap agreements. I'd like to thank my CFTC colleagues on the definitions team, including from OGC, Terry Arbit, Mark Pfeiffer, and David Aaron in particular, Dan Berkovitz, our General Counsel, and members from other divisions, including Rose Troya, Somi Song, and Steve Kane, as well as our SEC colleagues, including Brian Bussey and the SEC team for their contributions to the proposal. I should say this really was a team effort. In a wide-ranging rulemaking, we tapped in to the expertise of a lot of people, and I'm very grateful for that. In developing this proposed rule and interpretive guidance, we reviewed more than 80 written comments in response to an advance notice of proposed rulemaking that the commissions issued last summer. We met with market participants, trade associations, and other members of the public. We had many meetings with our SEC colleagues and consulted with the Federal Reserve Board as well as the other prudential regulators. We're grateful for the input we've had so far, and we look forward to continuing to meet with the public and our fellow regulators to develop the final rules and interpretive guidance. The Dodd-Frank Act contains detailed and specific definitions of the terms swap and security-based swap, which were designed to comprehensively cover previously unregulated derivatives, including interest rate swaps, currency swaps, commodity swaps, equity swaps, and credit default swaps. We do not believe that extensive further definition of these terms is necessary. Many commenters to the ANPR pointed out, however, that if read expansively, the definitions could cover other products, such as insurance, that traditionally have not been considered to be swaps, and nothing in the legislative history of the Dodd-Frank Act suggests that Congress intended such products to be regulated as swaps or security-based swaps. To address these concerns raised by the commenters, the proposal clarifies that certain products are not swaps or security-based swaps. In brief, with respect to insurance, and without going into the details, the proposal provides that regulated insurance products that are offered by regulated insurance companies are not swaps or security-based swaps. In addition, commenters to the ANPR requested that the commissions clarify that certain consumer and commercial arrangements that historically have not been considered swaps or security-based swaps, such as consumer mortgage rate locks, contracts to lock the price of home heating oil, and contracts related to inventory or equipment in someone's business should not be considered within the swap definition. The proposal contains interpretive guidance to clarify that these types of products are not swaps or security-based swaps. Commenters to the ANPR also asked for clarification regarding the forward contract exclusion from the swap definition. Under the Commodity Exchange Act, forward contracts are excluded from futures regulation. The Dodd-Frank Act excluded from the swap definition, quote, any sale of a non-financial commodity or security for deferred shipment or delivery, so long as the transaction is intended to be physically settled. Although the wording of this forward exclusion is slightly different than the forward exclusion applicable to futures, there is legislative history to the Dodd-Frank Act indicating that Congress intended that the commissions interpret the two exclusions consistently. To implement this congressional intent, the proposal provides guidance that the forward contract exclusion from the swap definition with respect to non-financial commodities should be interpreted in a manner consistent with the CFTC's historical interpretation of the forward contract exclusion from futures. It further clarifies that book-out transactions in non-financial commodities that meet the requirements specified in the Commission's Brent interpretation and that are effectuated through a subsequent separately negotiated agreement should qualify for the forward exclusion from swaps and futures. Commenters also requested clarification regarding the CFTC's 1993 order exempting energy contracts from regulation under the CEA, the energy exemption, after enactment of the Dodd-Frank Act. The energy exemption basically extended the Brent interpretation and its guidance regarding bookouts to energy commodities other than oil. Because the proposal extends the Brent interpretation to all non-financial commodities, the proposal would withdraw the energy exemption as no longer necessary. So that wraps up the types of transactions that the proposal clarifies are not swaps or security-based swaps. Well, as I mentioned at the outset, the definitions of swap and security-based swap are comprehensive. The proposal does clarify that a few types of transactions in particular are swaps or security-based swaps. For example, foreign exchange forwards and swaps are defined as swaps, subject to the Treasury Secretary's determination to exempt them from the swap definition. Even if the Treasury Secretary determines to exempt them, however, the statute provides that certain provisions of the CEA apply to FX forwards and swaps, and the proposed regulations reflect this. The proposal also clarifies that certain FX products do not fall within the definitions of FX swaps and forwards, and so they are not subject to Treasury's determination to exempt. These products include foreign currency options, non-deliverable forwards involving foreign exchange, currency swaps, and cross-currency swaps. Outside of the FX suite of products, the proposal also would clarify that forward rate agreements, notwithstanding their forward label, are swaps. Proposed guidance would further clarify that options and swaps and forward swaps are swaps. The proposal then turns to the relationship between swaps and security-based swaps, how we distinguish the two. The proposal specifies a couple of principles about how agreements, contracts, or transactions that are subject to Title VII of the Dodd-Frank Act, which are referred to in the release as Title VII instruments, are to be classified as swaps, security-based swaps, or mixed swaps. That classification of a Title VII instrument is to be made at the time it is entered into, and that classification is retained throughout the tenor of the instrument unless the instrument is materially amended or modified. This simple guidance, we believe, is meant to ensure that market participants are not unnecessarily burdened in determining the classification of their Title VII instruments. The proposal goes on to clarify whether Title VII instruments are swaps, security-based swaps, or mixed swaps in certain areas. So, for example, clarification is provided regarding whether Title VII instruments based on interest rates, monetary rates, and yields are swaps or security-based swaps. In brief, Title VII instruments based on interest rates and other monetary rates, including interbank offer rates, money market rates, government target rates, and so forth, are swaps. Title VII instruments based on yields, where yield is used as a proxy for price or value of a security, loan, or certain security indexes, are security-based swaps, except in the case of U.S. Treasuries and certain other exempted securities, which the Dodd-Frank Act provides are swaps. In addition, guidance is provided in several other areas, including total return swaps and Title VII instruments based on futures contracts. In a few areas, the release sets out alternative approaches and requests comment. The proposal then turns to the use of the term narrow-based security index in the security-based swap definition. In general, with respect to Title VII instruments on security indexes, the CFTC has jurisdiction over such instruments on broad-based security indexes, while the SEC has jurisdiction over Title VII instruments on narrow-based security indexes. The proposal clarifies that the existing criteria for determining whether a security index is narrow-based and the past guidance of the commissions regarding those criteria in the context of security futures applies to Title VII instruments. Credit default swaps are also subject to this same jurisdictional division. CDS on broad-based security indexes are regulated by the CFTC, while CDS on narrow-based security indexes, as well as CDS on single names or loans, are regulated by the SEC. The proposal provides new criteria tailored to CDS for determining if CDS is based on an index that is a narrow-based security index. In addition, it provides guidance regarding the term index and provides proposed rule governing tolerance and grace periods for the Title VII instruments on security indexes traded on trading platforms. So that's the end of swap and security-based swap. Turning to mixed swaps, which are both swaps and security-based swaps, the proposal expresses the expectation that this will be a narrow category. It addresses regulatory treatment of bilateral uncleared mixed swaps where one counterparty is a dual registrant with the CFTC and the SEC. It also establishes a process for requesting a joint order from the commissions to determine the appropriate regulatory treatment of mixed swaps that do not fall into that category. With regard to security-based swap agreements, or SBSAs, the Dodd-Frank Act provides the SEC with anti-fraud authority over and access to information from certain CFTC-regulated entities regarding SBSAs, which are a type of swap related to securities over which the CFTC has full regulatory authority under the statute. The proposal provides guidance on SBSAs and clarifies that there would not be additional books and records requirements regarding SBSAs other than those that have been proposed by the CFTC for swaps. The proposal also includes a process for members of the public to request a joint interpretation from the commissions regarding whether a Title VII instrument is a swap, security-based swap, or mixed swap. Finally, it includes proposed anti-evasion rules and guidance for the CFTC. These are the highlights of the proposal. Because of time constraints, I've necessarily skipped over many details, but if the Commission votes today to publish this proposal in the Federal Register, the public will be able to review it in its entirety and provide comments. Again, we would welcome comments on all aspects of the proposal. Thank you for your attention, and I and the team would welcome any questions you may have.
Thank you so much, Julian and the team. With that, I would entertain a motion to accept the staff recommendation on this joint rule on product definition.
So moved.
Second?
With that, I guess I'm just going to ask a few questions. I do support this rule. I think it's, as Julian said, that the Dodd-Frank Act is very specific with regard to the definition of swap and securities-based swap. But the CFTC was directed, along with the SEC, to give further definition, and we worked closely with the SEC in consultation with the Federal Reserve on the proposed rule to define these terms. And we were greatly benefited by the public comment. I think it was somewhere in the order of 80 plus specific comments to the ANPR, but even with regard to many other meetings and many other commenters, I think that number probably is a low count, the 80. And the statute is clear. Interest rate swaps, currency swaps, commodity swaps, equity swaps, CDS, or swaps. And I think the rule is consistent with that. And I think where there was ambiguity, we've addressed that. Insurance offered by a regulated insurance company is not a swap. Commercial transactions, what the public normally thinks of as commercial transactions or consumer transactions, are not swaps. And in a very important area for this agency is the question of forwards. Forwards in the commodity space. And specifically, Congress addressed this and said that any sale of a non-financial commodity or security for deferred shipment or delivery, so long as the transaction is intended to be physically settled, that's not a swap. We've had something similar, not identical words, but very similar in the Commodities and Exchange Act since the 1930s, that forwards were not futures, and I'm glad to see that I think this rule supports that, but we're going to look forward to public comment on this as well. But Julian, I do have one question in that area because it's come up in so many meetings with farm co-ops and energy companies and so forth. If somebody has an embedded option in a forward, where did we come out on that?
Basically, we followed the Commission's decision, recent decision in Ray Wright, and which also followed the OGC interpretation from 1985, which basically says that if the option is related to price, then we won't consider that to be a swap. But if the optionality is to delivery, then that's something we have to take a look at.
Did we ask further questions on that regard to get public comment, particularly in the electricity area? I think I seem to have had a recent meeting with a bunch of very thoughtful people from electricity companies that had some questions on this and wanted to be able to comment. So I just want to make sure we did include some questions in that regard.
Yes, we did.
Good. I think further, consistent with Dodd-Frank, the proposal clarifies that these issues as to where the line is between the SEC and the CFTC, and it took us a few extra months. But I think this was time well spent because I think it will provide the public greater certainty as to the jurisdictional lines without creating gaps in the regulatory oversight. But I just had a couple questions there and credit default swaps. So if a credit default swap is on a single name or on a narrow group of names, it would be regulated by the SEC. Is that correct?
That's correct.
And I thought that one provision that's in here that you might explain a little bit is, what if it was on a broad group, maybe even it's 50 or 100 names, but one of the counterparties has an opportunity to change those names or actually direct what the names are after the fact?
Well, in that situation, if the party does have discretion, then it would be a security-based swap, or it could be a mixed swap. If the parties do not have that discretion, it's set right from the start, then it would be a broad-based index and subject to CFTC.
Right. So if discretion's retained, it's over a securities-based swap and at the SEC. But if it's what's the classic broad-based indices, whether it's sort of iTrax or CDX in this marketplace, those would be considered swaps, as I understand it, generally speaking. And then could you comment on the anti-invasion provision a little further as to what we did there?
Well, essentially what we did was our proposed rule further defines as a swap a transaction that has been intentionally entered into to evade Dodd-Frank Act requirements. We are comfortable, our general counsel is comfortable that we have the authority to do this, and we think that it makes sense. What it would do is we would treat the transaction as a swap, and we have intent built into it so that people will, it will have to be shown that somebody intentionally structured it to evade, not and if they have a valid business purpose or something like that, then they have a valid defense. So we think it is cabined in enough so that the market won't be chilled.
So what you're saying, or Dan?
That's correct. We've examined the precedent for anti-evasion language in other statutes and case law and interpretation. And generally, agencies are given a wide range in applying anti-evasion. We have narrowly crafted it, as Julian mentioned, so that it has to be structured willfully to evade the definitional requirements in order for the instrument to be captured within under this provision. And one of the factors is whether there's a legitimate business purpose for the structuring the transaction in that particular manner. But we're comfortable with the proposal.
Thank you. Commissioner Dunn.
Thank you, Mr. Chairman. I commend the staff for the tough work on putting this interp out. I note that the ANPR went out back in August of 2010 with closing in September of 2010, and staffs between this CFTC and SEC worked jointly on putting these proposals together, and as staffs often do, they do have different interpretations of who's in charge of what. And Mr. Chairman, I commend you and Chairwoman Shapiro for the direction of giving the staffs and getting us to where we are. Julian, could you elaborate on what are the major areas of difference between what the SEC is proposing today and what we have here in the CFTC proposal?
Yes, Commissioner. We have, I guess, there are 4 areas where we have differences with the SEC. The first is anti-evasion, although that is because our statute requires us to further define swap and security-based swap to prevent evasion, whereas the SEC has discretionary authority to do so under the statute, and so they are requesting comment on the issue. So the remaining 3 are the ones that staff had differences on, and those are insurance on swaps, whether they should be regulated as swaps or security-based swaps. Swaps linked to futures on the 21 foreign sovereign debt securities that SEC has exempted for purposes of futures trading. And the last one is with respect to index CDS, whether if the index is provided by a third-party index provider and it's listed for trading on a DCM, CEF, or registered FBOT, whether that should be under the CFTC's jurisdiction and satisfy what's called the public information test prong of the index CDS test. But, overall, in my judgment, I mean, this is an over 300-page document. The staffs did reach agreement on a lot of topics and on a comprehensive rulemaking covering various topics. So we do have these areas, but we expressed our different views, and we're requesting comment to hopefully better inform you and they to inform the SEC on the appropriate treatment of these products.
I note that there's a provision that a person can ask for a joint interpretation when there seems to be at loggerheads, and that there's a period of time that the 2 commissions are required to answer that request for joint interpretation. Could you amplify on that a bit?
Sure. Yes. Under the process, the 2 commissions would have 120 days in order to make a determination. Based on our past experience and some of these new products with the SEC, lots of times these things have gone on, for years sometimes. And so we thought that it would be good to have a process where people can come in, request an interpretation about the status of their instrument, and within a set time frame. And moreover, if we can't do it in the 120-day period of time, we will publicly state our reasons why we can't, so that there is accountability as well. So we think that that is a very good proposal.
Thank you, Julian. Mr. Chairman, I will. I know other commissioners have questions, so I'll yield back to you.
Thank you, Commissioner Dunn. Commissioner Summers.
Thank you, Mr. Chairman. I have a couple of different questions First of all, on the issue that I raised in my opening statement on the multilateral development institutions, and have a question with regard, I guess, first of all, to say thank you for the discussion and questions that you had drafted that were in the earlier draft, but to ask whether or not you believe that there are any specific concerns that you have with asking these questions. I intend on putting them in a dissent and ask you if you have any concerns with asking questions with regard to their concerns.
Commissioner, we had included those questions in the draft for sort of discussion purposes, and they certainly serve that purpose. As staff thought about the issue some more, which had come up kind of late in our process, our concern about it was that it was focusing, as you say, on a very legitimate question, but in the wrong place. This is a product definition rulemaking, where, as Julian was explaining, we're trying to provide guidance to the public, what is a swap, what isn't a swap, and how you distinguish swaps from security-based swaps. I think everybody agrees these products by these multilateral development institutions are swaps. So staff was reluctant to ask questions about whether there should be exclusions to the swap definition based on the party that's entering into the transaction. We think that's to use the phrase, slippery slope that we prefer not to go down. We have met with some of these organizations, and what we have stressed to them is that what staff believes would be more helpful information, the questions will be more helpful to us, is to talk about these entities and these transactions in the context of the specific requirements of Dodd-Frank, the clearing requirement, capital and margin requirements, reporting requirements, and help us try to understand where difficulties may exist and where there may not be difficulties. If they're carved out of the swap definition, they're out, the counterparties are out, and that was the concern. It may be that there are good and valid reasons why certain requirements under Dodd-Frank should not apply, those are questions that we would much prefer to be discussing with these kind of organizations.
I appreciate that. I don't have a specific solution in mind for how to take care or address their concerns, but because we have not included any of these questions in previous proposals, I'm just hoping that by including some questions with regard to it, we'll be able to get comment and then put it in wherever staff agrees is an appropriate place. An additional question I have on this subject is with regard to their comment letter, which is on behalf of a number of the multilateral development institutions, and they reference different privileges and immunities that are conferred on them by a series of statutes dating back to Bretton Woods. And I'm wondering whether you have analyzed our regulation of the activities of these entities and whether or not they would conflict with any of these other statutes and the immunities or privileges that have been granted to them.
We have read those letters, and we have considered the issue. I don't think we've reached, from staff's point of view, a firm judgment on it. Those certainly are important questions that we do need to determine how, when Congress layered on the Dodd-Frank Act, how that does apply to pre-existing statutory regimes. And so there is the question of the authority and the extent to which the Commission can reach some of these activities. We welcome comment on that question. I would also say in a related vein, because Commissioner, you referenced the multilateral development institutions, but there's various other sorts of international organizations as well, and the question of the extraterritorial reach of Title VII is also a question that just permeates all of the efforts that the Commission is undertaking. We've got some very thoughtful comment letters in response to various of the proposed rulemakings on the Commission's extraterritorial application of Title VII, and those are issues that the staff is working on as people start looking to develop final rules on the specific requirements.
Thank you. I think for the record, I'd also like to note that in the EU draft, EMIR considers the status of these entities and suggests that their regulation will not apply to them. So in order to be consistent with our international counterparts, I think that this is something that we should consider. On a couple of other issues where we have inconsistencies, and in reference to Commissioner Dunn's question with regard to where there are differences, I'm wondering on both of the issues of the insurance wraps and the futures on sovereign debt, I'm wondering if what your concerns would be with taking the SEC's approach on either one of those issues, and specifically on the insurance wraps, would those policies go unregulated if we were to adopt the SEC's approach?
Well, I guess in the case of insurance on swaps, that would really be up to the state regulators, how they would want to address that. If we didn't deal with it, and I guess we were concerned with respect to the monolines that this was an issue, and we haven't sort of definitively stated that insurance on a swap is a swap. We are requesting comment on it, though, because of the economic similarities that we think that could be drawn between the two. I guess we haven't really made up our minds on that issue yet. So I think it's just a matter of we'd like to get comment from the public and see what they come back with. On foreign sovereign debt, I guess the issue there really is that futures on the foreign sovereign debt are traded on our regulated markets, designated contract markets. I think the CME just announced that they're going to do yield spreads on the foreign sovereigns, futures on them. And, the issue is really, a guiding principle of Dodd-Frank was whatever we had regulation over in futures, we would have regulation over swaps in order to prevent, things like gaming and arbitrage and, that our regulatory regime would apply. The SEC, though, has a concern on their side because security-based swaps on foreign sovereigns, the instruments themselves, are subject to them as security-based swaps. And so they see swaps on futures as a way to game or get out of the SEC's regulatory regime. I don't know what the resolution will be, and we're hoping to get some, good comments from the public how to deal with it. But that's the approach we've taken.
Thank you. I appreciate that. And just want to say specifically to this team, I know that you've had lots of long months and long hours putting all of this together, and we realize that a lot of your disagreements have ended in positive resolutions, so appreciate all of your hard work.
Yeah, I would echo that and extend that to the SEC who's meeting today too, because there are a remarkable number of places that the two staffs and the two commissions could find disagreement, and there are hundreds of places where we found resolution and agreement, and if there's 2 or 3 that we're asking the public for further help on, it's really to bring more into the discussion on these 2 or 3, and of course bring the public into where we've reached resolution as well, because final rules always change from the proposals. Commissioner Chilton?
Thanks, Mr. Chairman. The one thing about following Commissioner Summers is a lot of times it perks my interest in something, so thank you for that, Jill. I'm curious, Mr. Bergovitz, if the questions in Commissioner Summers' dissent get comments, can we include those comments as part of the decision-making process for the rule, the final rule, and if the Commission theoretically all thought that the comment said something and that we wanted to make a change reflective of the questions, is that something we could incorporate in a final rule?
Dan, can you broaden it to final rules, because it might elicit comments on other rules?
Yes, Commissioner Chilton and Mr. Chairman, that if we did receive comments on those questions, the Commission would be able to consider them and evaluate them and incorporate responses into the final rules. We would be able to do that.
Okay, so we have the latitude to alter the rule because of the questions that are asked in a dissent.
If the comment is submitted to the Commission, it wouldn't necessarily depend on how the commenter, what motivated the commenter, or what prompted the commenter to submit that comment. As long as the comment was relevant to the Commission's rule and pertained to something in the Commission's rule, the Commission could consider it in many instances. If it was a material comment that went to the significant material comment that went to the substance of rule, the Commission would be actually obligated to consider it. So,
I'm sorry. Then I'm just wondering, Dan, is it an easier mechanism for the public to comment on a question that the Commission would ask as part of the rule, as opposed to an individual commissioner, in this case Commissioner Summers, asking as part of her dissent? I mean, would it be an easier logistical mechanism for the staff to be looking at these questions as part of the actual proposal, as opposed to as part of a commissioner's dissent?
In terms of the staff reviewing the comments, it's been my experience and my observation to date, and we've gotten many comments, and the staff is working very hard to summarize all of the comments. We have a late comment policy where it's discretionary to consider them, and we have considered them in a number of instances, and staff has to date been able to incorporate all of those to the same extent. So to date, we've been able to accommodate all the comments regardless of, as I said, what might have motivated the commenter. I hope I'm answering the question. I might have missed it.
There's a mechanical thing on a joint rule, if I might, Commissioner Chilton, that this is a joint rule with the SEC that they're voting on at the same time. So that also is sort of a unique circumstance on this right here.
So, Mr. Chairman, so are you suggesting that if we added questions in our proposal, that might cause some idiosyncratic issues with the SEC's proposal?
Actually, I don't think we can, just as a matter of, like, their vote. I don't know if they voted on it 10 minutes ago or in half an hour from now. They're meeting today and voting on a joint rule in the same document.
Well, let me just ask, Mr. Berkovich, unless you know, Mr. Chairman, would questions somehow obfuscate the actual thing that we're doing in the rule, or do we have to have it just letter for letter, dotted I for dotted I on the proposal?
Well, let me try to answer, and I hope I'm answering the right question. Clearly, if the questions are within the four corners of the Commission's proposal, the proposal that the Commission has put forth in the Commission, in this case the Joint Commissions, if the questions are within that document, and the Commission considered a comment that was resulting from those comments, and then the Commission in the final rule went a certain direction because of those comments, the Commission, and it varied from the proposed rule, the Commission would have a very strong case that what it was doing was a logical outgrowth, that the public was on notice that the Commission was considering this alternative. If it's just in the case of a commissioner through a separate opinion or through a public speech or something outside of the four corners of that document that suggests to people, please submit your comments, we will consider them. As I said, the staff is obligated to consider the comment no matter how it's received if it's on the rule.
Okay.
It might be more difficult for the Commission to modify the final rule as a logical outgrowth, and that the public was on sufficient notice if it came through one of those different avenues rather than the four corners of the text. But that might be a different, where it would make a difference. But then again, it would depend on the circumstances or particular circumstances of the rule.
Okay. All right, thank you. Well, I commend Commissioner Summers for asking some questions, and I hope we get comments on them. I just had one final thought, and that is that this group has done a really good job on what I know is an arduous task. I remember right when Commissioner Summers and I started, I had a meeting with, I won't say who, but one individual who was concerned about an issue that Commissioner Summers had also raised a bunch of times on portfolio margining. And this individual said, well, that won't get resolved until so-and-so at the SEC dies or retires. And that's not the way that government should work. You know, the staff can only do so much, and then it will come up to the commissioners. And I think there's been some lack of leadership over the years because the staff just comes to loggerheads. And so this will require us on some of these issues that haven't been resolved to actually make a decision. And I look forward to doing so in a deliberative process, but one that's also expeditious and realizes the urgency of doing some of these things. Thank you, Mr. Chairman.
Thank you, Commissioner Chun. Commissioner Amalia.
Thank you. And following Jill and then following Bart, I always learn something, and I think that discussion, Commissioner Chilton, was very helpful, and I appreciate you asking those questions. Julian, I would like to go back to the insurance wrap issue, and if you could just characterize the differences between the two positions right now, and just enlighten me to the thinking behind why we came up with two different proposals.
Yes, well, Commissioner, we the SEC believes that insurance on a security-based swap should not be considered a security-based swap, we in the preamble we ask we say that the insurance may have characteristics that what we're asking about is what we're really trying to do is just how we distinguish it, or are they the same, how do we deal with it, and so we're asking comments about because the thing is, if you're insuring a swap, in some sense you are taking on the economic exposure of the counterparty to the swap, and and in the case of CDS in particular, the distinction is quite blurry, and so we are requesting comment on it.
Yeah, well, I think that's a great question, because I do agree that it is a blurry area, and especially with some of the products that have come out related to CDS. So I think I'm quite comfortable with that. Let me ask you about the forward exclusion. As I read it, the forward exclusion would continue to work the same way after this rule is implemented as it works today. Is that the consensus of what your reading is?
Yeah, that's essentially correct. We are extending it to all non-financial commodities, though, which in the past it was the Brent oil, and then energy expanded it to certain other energy commodities. We are, but the basic gist of it, the book out transactions would be excluded if they're entered into by commercials in reliance on the guidance in the Brent interp.
Okay. I am a little uncertain about the fixed for floating interest rate swap entered into in connection with a bond offering made by a municipality or a loan given to a corporation. So will we have jurisdiction over the swap, or does the SEC have jurisdiction over a floating fixed for?
If it's interest rate swap, we would have jurisdiction.
Okay. The FTR process, who will have to apply for an FTR exemption under the provision we've provided under 722?
That's right. Yeah, we aren't actually addressing that issue in this. We are saying that people will have to go through the Section 722 process to request an exemption.
If we exempt the FTR from regulation under this separate process, could you, and maybe this is outside your reach here, but will the RTO or ISO that FTR trades on also be exempt from regulation? Are we regulating the product or the entity?
Well, we're actually, I think, as part of a separate team, going to brief you tomorrow. So that's what that other team is considering right now. That they're coming in actually Friday again and speaking of Bob Wasserman and the rest of our team about that. So we're going towards an order on that, but it'll to be determined by the commission, of course.
Great, thank you. Again, let me offer my. This is. There's no way I'm going to go through all 300 pages in questions and ask you every question I have on this one, but I do think time is overdue for this rulemaking. It is essential going forward. So I'm pleased to get comment on it. It is complicated. It is extensive, and I know the public will need plenty of time to take a look and digest all of this. So I'm happy to put it out and support this to get the comment on it, and look forward to all the input coming back. So thank you very much for all your hard work on this.
I do have one question, Dan, if I can, because I thought Commissioner O'Malley was talking about this issue of electricity contracts traded on regional transmission organizations and ISOs as well. And it might be helpful for the public just to, if you want to give a little briefing. I know it's unusual, but just take 2 minutes and say, where does this stand? I know some of the, you've had, not just you, but the clearing folks and other folks have had extensive meetings with these organizations, and they do plan to put an order in front, put a request in front of us. But could you give us a little bit more?
Yes, Mr. Chairman, and I think this is consistent with what the approach Terry was mentioning earlier in connection with how to treat the consequences of something being a swap or not. These instruments are instruments that are used by regional transmission organizations and participants in the electricity market to provide some type of financial protection, financial certainty in the transmission of electricity. The question that the agency has been asked is, are these swaps? And if they're swaps, how would they be regulated? These instruments are used in regional transmission organizations, which are basically regulated by FERC. So there's the question of whether it's CFTC or FERC regulation. Congress provided in Dodd-Frank a specific provision that if the commission finds it's in the public interest to exempt these from regulation, that these instruments that are within FERC's jurisdiction, that it shall do so. So we've received many requests, are these swaps, and the agency, the staff's response is, we will treat these through the process that Congress set out in Section 4C to consider where they should be exempted. So the we've been engaged in discussions with the regional transmission organizations and these participants in the electricity market to determine what would be the appropriate terms and conditions of any exemptive order that the Commission would consider so that we could make such a public interest finding and not regulate these instruments. We've been in discussions with the regional transmissions organizations. We have had a very productive exchange of information, the types of information that we would need to make such a finding, that it would be in the public interest for an exemption to be issued, the types of information that we would need them to be submitted from them, and that process, that dialogue is going back and forth with the ultimate goal that they would be able to submit a document to us that we could consider.
I thank you. I don't know if any of them are listening, but I personally look forward to their submission. I think that would be a very constructive and consistent with congressional intent, so that'd be good. And I also want to thank all my fellow commissioners, particularly on this rule. I know that you've been patient. There's been the staff negotiations. There's even been the chairman negotiations. But I really, and I thank you for highlighting the need for this one to be done. And so a personal thanks to all of you that gave me your support and the staff support to end up with what I think is nearly total agreement with the SEC. There are these 2 or 3 items, but and I look forward to the public. But with that, Mr. Staywick, would you care to call the roll?
Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
The vote being in the affirmative, I look forward to hearing from the SEC if their vote's affirmative, and then I guess we'll jointly send it to the Federal Register. But I thank you so much, and whoever is up next, is it capital or segregation? Who is it? Segregation, Mr. Wasserman and team. As they're moving in, I also want to thank, I see Dave Johnson came back for a cameo, but Dave Johnson's one of our excellent staff who now works for Senator Pat Roberts, and it's just always good to see alumni here. The next group of presenters will include Bob Wasserman, John Lawton, Nancy Schnabel, Laura Estrada, all from the Commission's Division of Clearing and Intermediary Oversight, as well as Martin White from the Office of the General Counsel. They'll present the staff report on the proposed rule concerning protection of cleared swaps of customer contracts and collateral. There's also certain conforming amendments to the commodity broker bankruptcy provision. We've benefited by significant public input through an advance notice of proposed rulemaking and many other meetings. So I turn it over to the team.
Thank you, Mr. Chairman. I'm Bob Wasserman, lead for the segregation and bankruptcy team, and I'd first like to express my deep appreciation to my deputy, Nancy Leo Schnabel, and the other members of the team, Martin White of the Office of General Counsel, my DCIO colleagues Laura Estrada, John DeBoard, and Jennifer Bauer, and from the Office of Chief Economist David Reifin and Todd Prono. This work simply could not have happened without their assistance. As the chairman mentioned, last November the Commission published an advance notice of proposed rulemaking seeking to obtain comment about the issues of segregation and bankruptcy, and in particular cost issues relating to 4 models. A model for complete physical segregation, a model for complete legal segregation that had been referred to as legal segregation with commingling, a model for legal segregation with recourse that had been referred to as moving customers to the back of the waterfall, and the futures model, which had been referred to as the baseline model. The Commission asked members of the public to detail the costs they would incur and the benefits they would enjoy under those potential models. We received more than 30 very, very thoughtful comments from swaps customers, investment managers, futures commission merchants, and derivatives clearing organizations. These comments included a variety of keen observations: that swaps are significantly different from futures, that swaps customers were accustomed to bearing the costs and enjoying the benefits of individual collateral protection, that the futures model includes implicit costs to customers, and that the moral hazard issue applies both to derivatives clearing organization's incentive to risk manage its FCM members as much as to a customer's incentive to risk manage its FCM. In the comments, derivatives clearing organizations and firms expressed great concerns about the costs and about the very real transfer of wealth they would bear if customer collateral were protected individually. With mandatory clearing of swaps, baseline amounts of both cleared swaps, customer collateral, margin that is, and clearing guarantee funds, amounts required completely independent of this rulemaking would be many times larger than the corresponding amounts for futures today. Under the assumptions in those comments, one or both of these amounts would increase significantly depending on the model for customer collateral protection adopted by the Commission. Is denoted the critical importance of the ability to port positions of non-defaulting swaps customers in the event of an FCM insolvency, rather than liquidating those positions en masse. And a DCO observed that an FCM default could be preceded by a gradual decline, during which customers transferred positions and collateral to other FCMs, thereby rendering reliance on the collateral of those customers for use in a default scenario potentially imprudent, and calling into question some of the cost estimates discussed previously. As part of this process, we've also consulted with fellow financial regulators, both domestically and outside the U.S. In light of these comments, and in particular the fact that buy-side commenters indicated that they're accustomed to bearing the cost of individual collateral protection and the importance of portability, the notice of proposed rulemaking before you proposes the complete legal segregation model. Staff believes that this model strikes the best balance between achieving the goals of customer collateral protection and fostering portability at the least cost. Cost, however, does remain a continuing concern, and as a number of commissioners have alluded to earlier, the NPRM asks for comment on a very broad and deep variety of questions concerning alternative models, including legal segregation with recourse, the futures model, and various optional models. The discussions of optionality note the limitations that the bankruptcy code, in particular the requirement for ratable distribution. We look forward to comments on these issues to help us decide how to proceed. I should note that this notice of proposed rulemaking has a fairly wide scope of areas for natural outgrowth. I'd like to spend just a few moments discussing some of the specifics of the proposed regulations. I should note that regulations in proposed Part 22 apply only to cleared swaps contracts and collateral. They do not affect futures or futures customer collateral. Sections 22.1 through 22.10 in the proposal set forth the basic architecture for segregating cleared swaps customer collateral, and mostly parallel, or in a number of cases incorporate by reference, regulations 1.20 to 1.30 and 1.49, which are the corresponding regulations for futures. The definitions in Section 22.1 embody a recognition that 4D orders that the Commission has issued previously, which permit commingling in the futures account of foreign futures or swaps transactions, now under Dodd-Frank may also be issued pursuant to 4DF of the Commodity Exchange Act to permit commingling in the swaps account of exchange-traded futures or foreign futures transactions. To have cleared swaps accounts treated in accordance with U.S. bankruptcy law, Regulation 22.8 in the proposal requires that the situs of the account relationship between FCMs and their cleared swaps customers and between DCOs and their FCM members be located in the U.S. That speaks of the account relationship. The location of the actual collateral is regulated in 22.9 and incorporates the existing Regulation 1.49 as it applies to futures, or indeed 1.49 as it may be changed in the future. Proposed regulations 22.11 through 22.16 implement the complete legal segregation model, establishing a structure by which risk information is passed upstream daily. Swaps may be cleared through a multi-tier system, with certain FCMs clearing swaps directly and other FCMs clearing swaps for customers through one or more intermediate FCMs. 2211 requires clearing member FCMs to daily provide their DCOs information identifying the portfolio cleared for each swaps customer. 2212 requires DCOs to calculate daily the amount of collateral required for each customer. A DCO, however, will not be required to monitor whether a cleared swaps customer has in fact posted sufficient collateral. If not, the FCM essentially will have made a loan outside of the relationship with the DCO. Proposed Regulation 22.13 sets forth two tools that DCOs may use to manage the risk they incur. A DCO may increase the collateral required of particular cleared swaps customers, or may require FCM members to post additional collateral out of their own funds. And I should note that these tools are neither mandatory nor exclusive. Proposed Regulation 22.14 requires an FCM that fails to meet a margin call to provide such information and collateral from non-defaulting swaps customers as it has. And 22.15 requires a DCO to treat the collateral of each cleared swaps customer as belonging to that customer. I should note that what is protected is the value of the collateral, not any specific item. I should also note that the proposed rulemaking discusses the changes to 2215 that would be made in the event the Commission were to choose to adopt the the legal segregation with recourse model. And I should also note that if the Commission were to choose to adopt the futures model, essentially a number of these provisions would not need to be adopted. And so, in other words, they would not be replaced, but rather some would be pulled back. I'm going to take just a few moments to talk about the cost of supervision and oversight, another issue that was of concern that was mentioned previously. Day-to-day implementation of these proposed rules is sufficiently similar to the existing futures rules that, for any model that the Commission may adopt on final rulemaking, we do not expect a significant difference in monitoring methodology or cost over the present, either with respect to DSRO supervision of their member FCMs or with respect to CFTC staff supervision of DCOs. Now, again, I'm speaking solely with respect to this rule. Obviously, there are a lot of complications introduced by Dodd-Frank in terms of clearing swaps, and I'm not speaking of additional costs there, just with respect to this rule. And I should also note that because of the changes in risks, DCOs may well change the intensity of their supervision of their members' risk management of customers. The amendments to Part 190, the Commission's FCM bankruptcy regulations, are technical and conforming. For example, references to DCMs are amended to include parallel references to swaps execution facilities. Some amendments do apply to exchange-traded futures, but only with respect to an FCM in bankruptcy. And I should note, proposed amendments to Rule 190.06 clarify that nothing constrains the contractual right of a clearing organization to liquidate open commodity contracts and, in order to promote portability, prohibits the trustee from avoiding certain pre-petition transfers made by a clearing organization on behalf of customers. Partial transfers, which are provided for in the current rule, are still permitted because the transfer of all contracts and all accounts may be impracticable. I thank you for your attention and would be happy to answer your questions.
Thank you. I'll entertain a motion to support the staff recommendation on segregation of cleared swaps.
So moved.
Second?
I thank you. I will support the rule on protection of cleared swaps, but I do have a few questions, and I have a statement that will go, into the record. But Bob, as I understand it, we put out 4 options in this ANPR earlier. Is that correct?
Yes.
And where this comes out is, though it has rule text and there's a preferred path called legal segregation with operational commingling. First, did I get the title right?
I think at this point we've decided to call it complete legal segregation to distinguish it from.
All right. Maybe if I call it complete legal segregation, it comes out with that. Though, is it correct the funds could be operationally commingled?
Yes, indeed, under all of the models that we're continuing on.
Okay. So but as the rule text comes out with that, as I understand it, there's a series of well-written questions and options that retains this commission's flexibility, that in the final rule we might go with one of the other options that is in this document. Is that
Correct.
correct? And Mr. Berkovitz, is that correct? I just want to get the general counsel on the record. You can come back to the table and I'll ask it. He's got that BlackBerry all the time. The question is though we've, in the rule text on this, proposed one path, and that path is this legal segregation with what I'll call operational commingling, there are these other paths that are pretty fully described in the preamble. Does that retain our flexibility? If, you know, when the commenters come in, that's, 4 to 6 months from now, we have some flexibility here in the final rule.
Yes, Mr. Chairman, we've looked at this and we believe that there's adequate notice to the public that the Commission is considering these alternatives, and we're providing, seeking comment, and we believe it satisfies would satisfy the APA requirement for adequate notice and opportunity for comment on the proposed action and the alternatives in the document.
I ask that because I think it's very important for this commission to retain that flexibility, but also for the public to understand that we have that flexibility. So what Bob described on optionality, that the clearinghouses would have optionality, we could put that into the final rule text, correct? If we, subject to public comment, et cetera.
Yes, Mr. Chairman.
And so the people should take as seriously the preamble as they're taking the rule text. That there are a number of paths. The optionality is an important one. We could put that in the final rule.
We would consider it if it were to be adopted, presumably. Obviously, we'd look at the final document, but sufficient flexibility that it would be a logical outgrowth of what's being considered, and there's adequate notice and opportunity for public comment.
And in the same way, I want to make sure, because there's a lot of people that will comment on this. I gather, from the commenters, the 32 comments that came in the ANPR, that a number of firms on what's usually called the buy side, asset managers, hedge funds, money managers, mutual funds, were concerned and wanted to have such legal segregation. Is that correct?
Yes.
Yeah, but the clearinghouse's letters, as I read them, raised significant concerns about costs. Is that correct?
Most of them did. There was at least one exception.
Right. So I suspect the comments will come in on both sides of this debate, and that we still have the flexibility that to the final rule to possibly do exactly what we did here or move slightly away from it. Is that correct?
Yes, and thus I think those on each side of the debate should have great incentive to explain which models they like and which models they don't like and why.
Yeah. I will say I support this because I think that the swaps marketplace will be moving to clearing, that this is consistent with congressional intent, that one customer's funds or collateral are not used to secure another customer's funds. And I think Congress was specific about that. But we do have the futures model that has allowed for some of that for decades. So I very much look forward to the public's comments. Too, I'm going to keep an open mind on this, but because I think that we've made a proposal here, but we've clearly indicated to the public there's a very close second or third that might get, depending upon public comments, still is keeping an open mind towards. Commissioner Dunn.
My thanks to Mr. Wasserman and the team. They did the ANPR, they did the roundtable, and they've come up with this proposed rule, and this has been one that has really taken a lot of time of effort, and I appreciate what they have done in this arena. Bob, I'd like to know, in your opinion, which one of the proposals offers the best protection to customers from other customers' risk, and which proposal offers the best portability for the customer?
And I think that the model that the proposal has, namely the legal segregation with commingling or complete legal segregation, however we refer to it, provides the best protection for the customers in that under that model, the fellow customer collateral, that is to say the collateral of the non-defaulting customers, is protected from the start. And because that money is essentially set aside and cannot be accessed by the clearinghouse because of the default of another customer, that collateral then is available to support a transfer to a healthy FCM. I mean, a healthy FCM is not, in most cases, going to be eager to take a transfer unless the positions are supported by collateral. And so having that collateral available from the beginning is, I think, most conducive to portability.
Is it contemplated that there will be some type of risk assessment made to allow the customers to know exactly what they're at risk with the other entities involved?
I'm not sure I understand.
Will the customer know what's in the portfolio of the FCM they're using? And is there some type of assessment that will allow them to understand the risk that they have in the lane that they take for this clearing?
And so under the complete legal segregation, essentially, their risks would be separate from those of fellow customers. And so they would not be exposed to those risks. Under a number of other options, they would be exposed to those risks. There are, in the notice of proposed rulemaking, some questions as to how one might usefully advise customers of the risks. One of the issues is there's some limitations as to how far you can go on that. And so while there might, it seems to me, and I should note that we should, to a certain extent, wait for the comments, but on the one hand, you might profitably give out certain information about an FCM's policies in general. On the other hand, it's unlikely that customers would feel comfortable with FCMs sharing information with other customers about their specific risks. So I think there's some possibilities there, but also some limitations.
Then would it be incumbent upon the CCP or for the Commission to do some type of audit and financial review to determine that risk?
CCPs already, under the present futures system, do that to a certain extent. And we've seen some very excellent risk management review programs and DSRO supervision where, unlike a customer, where, of course, the customer coming in does not have that kind of relationship with the FCM to ask about fellow customers. There are certain privacy issues. The DCOs and the DSROs already are supervising their members. And so when they ask questions, they want to know, what are you doing both as your general policies and what are you doing with respect to specific customers? The DSRO, essentially by rule, has the power to essentially demand that information and to obtain it. And so I think what we will see is that the DCOs will build upon the excellent programs they already have. I think there may be some sharpening of incentives to the extent that they have some more closer financial exposure. But I rather expect that they'd be building on a base that's already there, namely their existing risk supervision programs.
Could I help out a little? Isn't the answer just straightforward? We as an agency can see into an FCM's risk, but a customer can't.
Yeah.
All right, I think that might be responsive to.
And the DCO.
That's right, that's it, isn't it?
Yeah.
It's just customer can't. I mean, you can answer other questions, but isn't that what he's asked?
Yes.
right.
We and the DCOs can do that. The customers cannot.
Thank you, Mr. Chairman, because it then builds upon my next question. And when you're saying that as far as CFTC goes, it's not going to require any additional staff, but won't we have to be able to perform some type of audit and financial review to make that determination?
Again, this is something that we already supervise in terms of the risk management that DCOs do with respect to their members. And so I think there may be some expansion of intensity, but it's essentially the same sort of program that we're already doing.
And I think I'd add that we do anticipate we would need additional staff for overseeing DCOs that will get new products, new members, and so forth. There'll be potentially new FCM. So in all those ways, I think swaps coming in will ultimately require more staff, probably in both the audit and review side and the risk surveillance side. But I think Bob's point is simply it's not so much the specific terms of this proposal as the general increase in number of registered entities, increase in volume, increase in number of products that they carry.
What do we anticipate increase in FCMs from what we currently have?
I'm not sure that we've come up with a number on that. I think that's really remains to be seen.
Yeah, I think Commissioner Dunn earlier last summer, and I think this has probably been modified last summer, we were at about 125 FCMs, and staff had said that preliminarily it might grow to as many as 200, and I think that was part of some of our budget work in the fall. But I think it would be good if DCIO sort of now, updates that, particularly as we start to, be more engaged with Congress on our 2012 and even start on 2013 budget submissions for OMB.
Thank you, Mr. Chairman. I thought the figure was 250. It may have been in the 200 range. Thank you.
Commissioner Summers.
Thank you, Mr. Chairman. To the team, this has been certainly no easy task. I mean, I think that there are legitimate concerns on both sides of this issue with market participants in the swaps market that want to preserve the framework they're used to operating under, and market participants in the futures side who want to preserve their futures model of doing business. And I certainly appreciate everything you've done to kind of balance the different interests that have been involved in this rulemaking. From the beginning, because of those two separate and distinct interests, had hoped that we could preserve some type of optionality, because I didn't think that this commission should be in the business of picking winners and losers. There are people who have frameworks already set up to provide complete legal segregation, and if that's the course we go, they will be a winner in this. There are people who have, of course, the futures model set up, and if we go a different direction, they will be losers. So I was hoping throughout this whole rulemaking that we would be able to preserve some type of flexibility and optionality. So I appreciate all the work you've done to include that in this proposal. The question I have with regard to that is the questions that we ask in the proposal about the optionality. I know that you have specific concerns about the bankruptcy code. And in one of the documents we received, it says that because the bankruptcy code requires customer property to be distributed ratably, we cannot give customers the option to choose. So if you could just quickly walk through what type of optionality, I think there are two different types of optionality we have suggested, and what is in the proposal for optionality.
So as you quite correctly noted, the concern is the requirement of the bankruptcy code that customer property be distributed ratably. And as the NPRM notes, we have to this point looked at things by account class with different types of products. So for instance, there is an account class for U.S. exchange-traded futures. There's an account class for foreign futures. We have built just about a year ago an account class for OTC swaps, and that's going to be essentially conformed in this proposed rulemaking, regardless of which option the Commission were ultimately to choose. But we've not said, for instance, that there would be an account class, each customer his own account class, and it seems to me that that goes a bit beyond what Congress let us do in the Bankruptcy Code and in Section 20 of the CEA. But there is mention of one possible approach that one could take, which is if a particular FCM, that legal entity, dealt with DCOs that followed a particular model, and only DCOs that followed that particular model, then a ratable distribution would follow that model. And so theoretically, and essentially the NPRM mentions this as a possibility and seeks comment on it, one could limit by the legal entity. Now, of course, you could have multiple legal entities that are affiliates, and one is the legal entity that deals with DCOs who adopt legal segregation with commingling. Another deals with DCOs that adopt the legal segregation with recourse or the futures model. And that is a potential way to deal with it. There are, to be sure, concerns in terms of competition, in terms of market structure, but ultimately that's for the commenters, and we look forward to hearing what folks say about the practicality of that. Fairly late in the process, we had a commenter mention possibilities, concepts of how one might do this by taking funds out of customer property and essentially leaving it to the DCO. We asked some questions about that. I think that concept very much needs further development, and it would be helpful to get comment that provides that further development. On the other hand, I think given that this is mentioned in the notice of proposed rulemaking, it would likely behoove all interested commenters to give their views on that. I hope that's been responsive.
Absolutely. Thank you, Bob. And I think that what I would encourage is all the interested parties to specifically comment on the costs associated with some of these different options and whether or not it satisfies, the intent that we're meaning to bring to this proposal. And again, want to say thank you to this whole team. You've done a lot of thinking outside the box to try to figure out what we can do to solve some of these very complicated issues. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton.
Just real quickly, Mr. Chairman, I agree on knowing what the costs are, and as Commissioner Dunn, ask all the time, it's also interesting to know what it's going to cost the agency, and we need to know what we think it's going to cost consumers. I am interested in what Mr. Wasserman was talking about there at the end about another idea related to taking it out of customers' property. So I look forward to comments. I do think this is a good example of us further fine-tuning where we might be headed. I've been really impressed with the comments we received and visited a bunch of folks around the country on this issue, and It's been very helpful, and this is what the rulemaking process is about, because we're further defining things, and I think we're going to end up at a good place. But these comments have been absolutely critical to us moving forward in the process. I just want to commend the team, commend Bob, and I don't have any questions. Good job.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you, Mr. Chairman. I think I'd like to follow up on Commissioner Dunn's questioning about understanding what FCMs are, what their exposures are, and what customers can expect. Obviously, in the future space, we have a well-known FCMs. We've got a track record, et cetera. We've got a very good track record in omnibus clearing, and the FCMs and DCOs have worked really well together. Obviously, we're creating a new, and we're creating swaps world's a brand new world, and I think customers ought to be a little more informed than the basics of what we've provided in the future space. We have a monthly report that is a quantitative analysis of seg funds and Part 30 funds, and it's an Excel spreadsheet saying how much is in each account, but it doesn't give you any qualitative analysis of the risks or counterparties or anything like that. And I'm sensitive to disclosing counterparty risk or other customer risk in a fund, but I think in the swaps world where we know so little about it and understanding what your relationships, we ought to do a better job to educate customers about who they're sharing with. Obviously, the team has come up with a solution to that is don't expose yourself to any other customers, which is one option, but I think we need to understand what the costs of that are, and we have not heard a unanimous cry for total segregation, this legal segregation, and we have some people asking for this omnibus model. So I think marrying better information with the possibility of having an omnibus model will certainly give customers better information. You have put some questions in here. I think we can do a better job of really roughing those out, and I will expect hopefully in a final rule that we have a better idea of what questions we want to ask and what we can ask of the FCM and disclose to customers. It won't disclose positions, but at the same time give them more information going forward. Let me get on to some of the questions that I have here. Can you the cost-benefit analysis in the back of this? You use words like tend and likely, and it's a little fuzzy. I'd like to go back a step. What kind of cost did commenters to the ANPR anticipate would accompany complete legal segregation model? Because I didn't see that. I don't think I saw the specific numbers that were referenced in our cost-benefit analysis that were raised in those questions. Were they in there?
I'm pretty sure. I think they were, but in any event, yeah, I'm pretty sure they were discussed, certainly discussed in the discussion of the comments. And
Okay.
I should note,
Well, maybe you could share, you just summarize those for me, if you will.
and so there were really two types of costs. One cost is operational costs, essentially doing things under the model that one is not doing today that costs staff time, computer programming, that sort of thing. And the comments indicated that those costs would actually be fairly modest. Something on the order of per FCM, a one-time cost increase of about $800,000 to $1 million, and a recurring annual cost with a median estimate of about $700,000. And similar costs in terms of DCOs. There were conflicting discussions with respect to what I would call risk costs. That is to say, by essentially removing the fellow customer collateral from the equation, essentially you're going to be subjecting the DCOs and the other clearing members to increased costs. And there are two ways they can approach that. One is to increase the amount of margin each entity, each customer provides with respect to each position. Another approach is through the guarantee fund. And one could essentially increase the amount in the guarantee fund to meet a potential default, or one could do a combination of the two. And so what some folks said is, well, look, first off, I should note that the numbers are large because the baseline is large. And so, for instance, ISDA was talking about something on the order of a baseline collateral requirement of some $500 billion. And they were talking about an increase of some 70% of that in the event one goes to individual customer protection. If the DCOs were to take that approach by essentially saying going from a 99th percentile margin to a 99.9 percentile margin. An alternative approach is through the guarantee fund. And we had baseline estimates for guarantee funds without this rule of some $128 billion. And this is essentially because more swaps is more business, more risks, and therefore that baseline would increase with that. And we've seen estimates of increases in that of some $50 billion to $128 billion, essentially a doubling. On the other hand, we had, as I mentioned, one comment which said, wait a minute, how the change here is not so great, because the change is based on an assumption that you're saying that fellow customer collateral will be there in the event of a default. And there are some kinds of defaults, very sudden default, where that likely would be the case. But what we've seen also are some other kinds of defaults. Lehman immediately comes to mind, where essentially the FCM was on a downward slope for a couple of days before its insolvency. During that time, customers are free to, and indeed in many cases may have fiduciary obligations to, take their money and move it to another FCM. They have every right to do that. And if they do, that money is not going to be there. So if you set up a default resource scenario that assumes that money is going to be there and it isn't, then you could have a bit of a problem when a default might actually come. And so that suggestion is, well, maybe that's not prudent, in which event, if you don't rely on that, it's not a cost.
Does this proposed rulemaking lean towards the using a guarantee fund approach, which poses some risk, as you've just identified, or leading towards more margin? Do you have a personal preference?
I don't have a preference as to margin versus guarantee fund, and the document does not express a preference either way. That would be in the good judgment of the DCOs based on how they would deal with the rules as they are ultimately adopted.
Okay. Has this team or the Office of the Chief Economist done an economic cost-benefit analysis on the numbers identified on the comments in the ANPR?
Yeah, and the cost-benefit analysis in the document is in large part based on the comments. I should note one of the things that they pointed out is that to the extent that customers are free to leave before a default, that also affects the benefits, because essentially some customers, in other words, might be able to save themselves depending upon how the default scenario plays out.
I'm still a little confused, because in the cost-benefit analysis in the back, it talked about these different scenarios, but it said, it didn't give hard dollar numbers, and it had softer words like tend and likely, and it didn't give me a real good sense of hard economic analysis based on these costs.
And
Nancy, do you want to just take it? Because I see you have the papers there.
Well, there are numbers. It's on page 107 and 109, and those numbers are the same as those up front in the preamble, where we talked about commenters giving the risk costs and the operational estimates. So there are numbers, and if there are any other economic analysis that you, I guess, Commissioner Amalia wanted to know about, please ask us about it.
Yeah, I was looking on page 111, 114, and some of these. I'll get back with you on that. I just need to talk with you a little bit more about how rigorous this analysis has been, and if we have a good grasp on the likely outcomes of either one of these scenarios. Let me just, I do want to thank the teams for the flexibility. This is a tough question, trying to understand the implications of any decision we make. I differ slightly with the chairman on the certainty of Congress on this matter and the legal requirement, but it is what it is, and I'm comfortable because I think we do have options to consider going forward, and if Congress wants to reflect on this further, I think that would certainly be helpful, but it would at least we're not foreclosing some options here, and I'm willing to support this going forward. I do want to have a little more discussion about some qualitative customer information that we can talk about in the swaps space and going forward, and maybe improve upon that and be less asking questions and be a little more forceful in what it is that would inform customers going forward about fellow customer risk. Let me close there and we'll let it vote.
Thank you, Commissioner Amalia. Mr. Staywick.
Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
No.
Commissioner Summers, no. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
I thank you. I thank the team. Now that it is actually passed and we'll be sending it to the Federal Register, I guess I get a chance to do something I'm allowed to do, is to direct the staff to do something, and I'll do it publicly. I think within this 60-day comment period, I'd like to direct you to have a staff roundtable. I think that this would be a good thing in the middle, maybe like a month into the roundtable. Let people sort of start digesting this, but hopefully not at the end of the 60 days, so that people can really, their comments can be reactive also to the staff roundtable. And I would suggest get those who support, those from the buy side and elsewhere that support, those who have reservations, try to explore these cost issues further, and fill this room if you need to, because it's a really important issue. But I guess I get under this, I checked, they said I could direct you to do this. So, but if you could do that in the middle of the 60-day period, I think it'd be very helpful.
We'll make it so.
Thank you. With that, I think we'll move to the capital rule. Tom Smith, Thelma Diaz, John Lawton. This capital rule, the other half of peanut butter and jelly, because you were here as well on the margin rule. I thank you for all of your diligent work, and I hand the floor to you.
Thank you very much. And first, I'd like to acknowledge the other members of our team who are not sitting with us, Jennifer Bauer, Todd Prano, Beverly
You might
Lowe.
come a little closer to the mic or move
Yes,
the mic.
and John Paul Rothenberg. Staff requests commission approval to publish in the Federal Register 2 documents.
Why don't you just pull it closer?
Okay, is that good now? There we go. The first is the notice of proposed rulemaking titled Capital Requirements of Swap Dealers and Major Swap Participants. The second is a notice of the extension of the comment period for the notice of proposed rulemaking titled Margin Requirements for Uncleared Swaps, uncleared swaps for swap dealers and major swaps participants, which was approved by the Commission for publication on April 12, 2011. The extension of the comment period for the margin rules would be published on the same day as the proposed capital rules to ensure that the comment periods for both rules run concurrently for a full 60-day period. The proposed capital rule would implement provisions within Section 731 of the Dodd-Frank Act that direct the Commission to adopt regulations imposing capital requirements and financial condition reporting requirements on swap dealers and major swap participants. The Dodd-Frank Act applies a bifurcated approach that requires each swap dealer and MSP for which there is a prudential regulator to meet the capital requirements established by the applicable prudential regulator, and each swap dealer and MSP for which there is no prudential regulator, including non-bank subsidiaries of bank holding companies, to meet capital requirements adopted by the Commission. In addition, the SEC is directed to adopt capital requirements for security-based swap dealers and major security-based swap participants that are not subject to prudential regulation. The Dodd-Frank Act also requires a minimum level of coordination and consultation with respect to capital. The regulatory agencies are required to consult at least annually, and the capital regulations are, to the maximum extent practicable, required to be comparable. Consistent with this provision, the Commission has had several meetings with the prudential regulators and the SEC and has provided the prudential regulators and the SEC with an opportunity to review and comment upon the proposed regulations. In developing the NPR, Commission staff also considered the many pre-comment period letters that have been submitted, the issues raised in meetings with outside parties, all of which are listed on the CFTC website, and the information obtained during a public roundtable that was jointly hosted by the CFTC and SEC and attended by representatives of each of the prudential regulators. The proposed regulations, to a great extent, draw upon existing Commission and bank capital requirements. The proposed capital regulations are risk-sensitive, meaning that a swap dealer or MSP's capital requirement would increase or decrease corresponding with the level of market and credit risk associated with its swaps transactions. The regulations also would establish a minimum level of $20 million of regulatory capital that each swap dealer or MSP would be required to maintain. This minimum capital requirement is consistent with recent amendments to the Commodity Exchange Act, where a $20 million minimum capital requirement was imposed on Futures Commission merchants that engaged in OTC transactions in foreign currency. The minimum capital requirement is intended to ensure that swap dealers and MSPs maintain a minimum level of financial resources to meet its financial obligation, including obligations to end users. The proposed regulations effectively impose capital requirements on swap dealers and MSPs based on one of three categories. First, a swap dealer or MSP that is also registered as a Futures Commission merchant would be required to comply with existing CFTC FCM capital requirements. The minimum regulatory requirement would increase from $1 million of adjusted net capital to $20 million. An SD or MSP also will be required to compute its risk-based capital requirement based upon 8% of the risk margin associated with cleared futures and cleared swap positions carried by the FCM in customer and non-customer accounts. The risk-based capital requirement is currently part of the capital rule. Second, a non-bank swap dealer or MSP that also is part of a bank holding company would be required to meet the capital requirements established by the Federal Reserve Bank as if the SD or MSP was a banking entity. The proposal would also establish a minimum regulatory capital requirement of $20 million of Tier 1 capital as defined by banking regulations. All other swap dealers and MSPs, i.e. those that are not FCMs or banks, would be required to maintain regulatory capital as measured by tangible net equity. The proposal would establish a minimum amount of tangible net equity that was equal to or greater than $20 million, plus an additional market risk charge and credit risk charge for the uncleared swap positions. Tangible net equity is defined as net equity as computed under generally accepted accounting principles less intangible assets. SDs and MSPs that use capital models reviewed by prudential regulators or the SEC could request Commission approval to use the same models for computing market risk and credit risk capital charges. The proposal further provides that the Commission may approve capital models for SDs and MSPs that do not have models reviewed by the SEC or prudential regulators if adequate resources become available for the Commission to conduct appropriate reviews and continuing assessments of such models. Pending the implementation of such a program, the proposal provides that swap dealers and MSPs that are FCMs would continue to apply existing market risk and credit risk requirements set forth in Regulation 1.17. Other swap dealers and MSPs would use Basel-based standardized or grid approach to compute market risk and credit risk capital charges. The proposed financial condition reporting requirements for swap dealers and MSPs are comparable to existing FCM financial condition reporting requirements. SDs and MSPs would be required to maintain current ledgers or similar records which support each transaction affecting their assets, liabilities, income and expenses, and capital accounts. SDs and MSPs also will be required to file monthly unaudited financial reports with the Commission. Each swap dealer and MSP also will be required to file an annual audited financial statement with the Commission. The audited and unaudited financial statements must be prepared using the English language and presented in accordance with generally accepted accounting principles as established in the United States. The notice of proposed rulemaking also includes proposed amendments to CFTC Financial Form 1FR FCM, consisting of a new segregation schedule for swaps customers' funds. The proposed schedule is consistent in design and format with the existing segregation schedules for Section 4D customer funds and for Part 30 secured funds. The proposed amendments would also revise the provisions governing the required audit scope of the independent public accountant's annual FCM audit to include the new segregation schedule for swaps customers. The proposal also establishes notice filing requirements for swap dealers and MSPs that are comparable to the existing notice filing requirements for FCMs. Such notice provisions include SDs or MSPs being undercapitalized or failing to maintain current books and records. The effective oversight of the implementation and ongoing compliance with the proposed new capital and financial condition reporting requirements would require significant additional resources, including additional staffing resources. In particular, if implemented, the proposal might require Commission staff to conduct financial oversight and financial examination of new registrants and potentially review and assess capital models. The Commission requested an additional 60 FTEs for the Division of Clearing and Intermediary Oversight in the FY 2012 budget, which represents an approximately 50% increase over current levels. If received, these additional resources would enhance the division's ability to perform oversight of SD and MSP registrant. That completes the overview of the proposed NPR, and we're pleased to take any questions.
Thank you, Tom and team. With that, I'll entertain a motion to support the staff recommendation on capital. Or to accept.
So moved.
Second.
Thank you. Tom, I have a number of questions. What I want to focus on is how this is divided up. So start with the traditional group, futures commission merchants who happen to decide they want to be a swap dealer. Their capital regime, is it correct, would in essence, with some small adjustments, but would in essence be what they currently have. Is that correct?
That's correct.
And as I understand it, that's a model that means it has to be very liquid, and the capital is computed in a way that provides for the liquidity of the futures commission merchant as a member of a clearinghouse.
That is correct.
And so we sort of maintain that.
We maintain that, yes.
Well, and then the next piece is, what if it's a swap dealer that's not a futures commission merchant? What we did there was we sort of put it in two different categories.
That's correct, depending on whether it was part of a bank holding company or any other type of swap dealer.
Okay. So I'm just sharing a little bit of how we got here, maybe with the public, but I mean, I've sort of, they all blur together, the numerous meetings I've been in, but as I understand it, swap dealers who were not futures commission merchants but would be part of a bank, a number of them came in and said, we're concerned that you might end up with capital rules that says it's the higher of the CFTC's capital rules or the Federal Reserve's capital rules. I mean, that was one of their key, questions.
That's correct, and they were pointing out that this swap business is done in the bank today in many instances, and it would be possibly be pushed out under Section 716 of Dodd-Frank into a subsidiary.
Right, which sometimes known as the Blanche-Lincoln push-out provision.
That's right, yes.
So where we ended up is, in essence, that if it's part of a bank holding company or if it's part of a systemically institution, I can't remember what SIFI stands for,
Systemically important financial institution.
It's the capital rules as set by the prudential regulators.
That's correct.
But we get to see it, we get to see all the modeling, we get to see the monthly reports.
Yes, they are, in effect, our registrant. And it is our capital rule and financial reporting that they're meeting.
Technically, it's our capital rule, but it piggybacks off the
Yes,
bank
our rule
capital.
defers to, that's right, for the purposes of computing it, you refer to the Federal Reserve Board's rules.
I checked that box. I like those two. Then the other category is the challenge of what if you're a non-bank, non-futures commission swap dealer, and that's where we get into firms that have come in, not a lot of firms, but somewhere, 10 or 15 of them over these months have come in and said, well, if we are a swap dealer, we can't imagine using bank capital rules. That's the large focus of the meetings when they've come in and met, at least with me.
That's right, and the reason being primarily is that they never were financially oriented institutions. They don't have a balance sheet structure that would be consistent with certainly an FCM or even a bank.
Right. So where we ended up is they can use tangible net worth, means they can count their factory, they can count their oil in the ground if they're in the oil business, their customer receivables, et cetera.
Correct.
So would they possibly end up with, it is possible there'd be some regulatory arbitrage that they might have lower capital standards than the bank capital standards would have been?
I believe so, yes. That'll be a lower standard.
I'm sorry, so that would be a lower standard.
A tangible
probably.
net equity would be a lower standard or an easier standard to meet, because
Right.
we're recognizing, or the proposed rules would recognize significantly more
Right.
types of, or classes of assets.
Right. And one of the issues also is, and this is the challenge of any regulatory agency setting capital standards, but capital standards help protect the public against a default. Is that right?
That's one of the things they do, yes.
What else do they do?
If it's an FCM, it allows, well, I guess it all can generate from that, because yes, it allows the ability to wind down operations, transfer customer funds to
Right,
another
right,
organization. In the context of a swap deal where you don't have customers, it's more counterparty relationships.
Right. Are you aware of any capital standard for insurance companies, which are called reserves, but capital standards or reserve requirements for insurance companies or securities firms or banks, where capital is only computed on some of your transactions, but not computed if your counterparty or your insurance client or your securities client has, is smaller or something like that?
No, I'm not.
So an insurance company, for instance, regulated by a state insurance company, would have to have reserves or capital even for their transactions with homeowners, insuring their houses, or auto insurance for somebody who has auto insurance. Isn't that right?
I believe so, yes.
So I support this rule. I think it's going to get a lot of public comment, as it should. I think it's very balanced, that we protect futures commission merchants and the liquidity, and that's at the core of lowering risk to clearinghouses. If somebody's not a futures commission merchant and it's part of a bank holding company or a systemically important financial institution, we pick up the calculations from the bank regulators so that we don't have sort of a higher than and sort of have regulatory arbitrage. And then if it's not part of a bank holding company, not systemically important financial institution, of course not a futures commission merchant, it's this tangible net worth approach. there may be some regulatory arbitrage. It will be a lower capital standard for those non-bank sort of commercial dealers.
That's correct, and we've included a question that asks for comment on some financial entities that may fall into that third category.
Would that be like financial entities, like if a high-frequency trader might want to do
Yeah,
this?
or a hedge fund or something that may, if it gets caught up in the swap dealer definition, if it's required to register as a swap dealer and
Right.
is a swap dealer.
And I'm very sensitive. End users, commercial end users should comment on this. Whether a dealer or just end users should comment on this. I'm very interested in their thoughts. Because capital does get priced into transactions. I mean, there's not a doubt, capital is part of how insurance companies price their insurance product, how banks price their loans. But ultimately, I support this because capital is a critical feature of supporting the market so that we know that end users, when they enter into a transaction, there's something standing behind the dealer when the dealer enters into the transaction. So, Commissioner Dunn?
Thank you, Mr. Chairman. If I can follow up a bit on your questioning here for those SDs and MSPs that are not a SIFI or FCM or part of a bank holding company, and you're going to base that capital on the tangible net equity. How is that going to be determined? How will the CFTC staff go about certifying what that tangible net equity is for that entity?
There will be reporting obligations imposed on the swap dealers, so we will see monthly and annual certified financial statements. The monthly will be unaudited. Depending on the resources that we have as well, as we do with FCMs today within the Division of Clearing and Intermediary Oversight, we have a program where we may conduct a direct examination of a FCM. That may extend also to a swap dealer or to an MSP. There will be some additional challenges dealing with these specific type of entities. Some of them may be very large energy or agricultural corporations or private companies, and that will be something that will present issues for staff that we'll have to address. We'll have to certainly get up to speed a bit more on how they operate, but I think we'll need to see the landscape of who does register first to identify that.
I like the concept of opening up the margin requirement being done concurrent so folks can look at both that and the capital requirements in there. But I do think this is going to be a considerable challenge to the CFTC staff. For those that are operating under their prudential regulator, do you contemplate that we're going to need some memorandums of understanding so that we are privy to all the information that we're going to need?
We certainly need to have an open dialogue with the Fed and other prudential regulators and with the Securities and Exchange Commission. Whether we need, I'm not sure of the mechanism of that. That's something that I'm going to take back. I know you raised this with me the other day, Commissioner, and I'm going to look into that with our Office of General Counsel as to what is the best mechanism to have a formal arrangement in place, or however we need to do that. But I don't have an answer whether it needs to be an MOU or some other mechanism that just to ensure that we can share information with each other about these entities and their models.
Do you in general have an idea how the application of the capital requirements will affect the swap pricing in this new regulatory regime?
Well, capital is certainly a cost for the swap dealer and for an MSP, and like all costs, it has to be absorbed by some party, be it the swap dealer, the MSP itself, be it counterparties, or somehow it has to be taken care of. Whether it will result in direct cost dollar for dollar being passed on to end users or to the counterparties, I'm certainly, I don't know the answer to that. But it is a cost. Some of these entities are not currently subject to capital requirements, potentially, so they'll come in and this will be an additional cost for them. But I sort of look at it in the context of general costs that are being absorbed by these organizations. And yes, they will have to be either internalized or passed on in some manner.
When we look at this cost-benefit analysis, and what we have for the final rule, we will also consider the cost for the commission for implementation. But on a broader scale, will you be looking at, without having that capital, that liquid capital available, what it might cost the general public and taxpayers per se?
Yes, certainly.
Thank you.
I just want to ask one question in the middle. The tangible net worth approach, doesn't it allow, I mean, if somebody's not a bank, that if it's factories or receivables, that they could be using the factory for other reasons? They might even have the factory securing other loans and so forth. Is that not right?
That's correct.
Yeah, so it's a very flexible approach.
Yes.
And if I have a worry it's too flexible, but I think that it's balanced. I think it addresses a lot of pre-proposal comments. But Commissioner Summers.
The chairman is suggesting that perhaps we do a perfection of a lien.
Just noting that we haven't. I mean, one of the questions that I got back in August and September was, is the CFTC going to make us segregate this capital? And it's clear we didn't make anybody segregate on this, the last category.
No.
Yeah. Commissioner Summers.
Thank you, Mr. Chairman. I think with this proposal, it's the same as the other two proposals that we've had before us today. The team has gone to a tremendous amount of work and effort to coordinate and collaborate with other regulators, and just want to say how much we appreciate your time into this proposal. My concerns with regard to margin are relatively the same, with capital are relatively the same as they were with margin. It's with regard to the review of models, the internal models, and the decision that has been made with regard to our limited resources, that with absent a prior approval of internal models, we may have to have some of these entities follow the Basel standardized approach, or I think what you called the grid approach yesterday. And I just want to note that I don't think this is optimal for these people. And if you could tell us who you think may be caught in this area where they wouldn't have internal models that had already been approved.
Okay. The main group will be the entities that are able to use the tangible net equity approach. Most likely, they're not going to be a bank, and they're not going to be an FCM. So those are entities that will be subject to this requirement to compute their market risk and credit risk using the Basel standardized approach. There could also be some FCMs that don't meet the level set by the Securities and Exchange Commission to use the alternative net capital approach, which is a models-based approach as well.
Thank you. And I think my other concern, as I said before on the margin rule, is that as we continue to collaborate with international regulators, I think on these couple of rules in particular, it's very important that we're as consistent as possible, because as we all know, capital is a place where if there is any inconsistency, it creates a huge opportunity for regulatory arbitrage. So hopefully, as we're all looking forward to applying the Basel standards, that we will all continue to be on the same page. Thank you.
You're welcome.
Thank you, Commissioner Summers. Commissioner Chilton.
Thanks, Mr. Chairman. I don't have any questions. I want to commend the team, Tom, and everybody for a good job. I look forward to getting the comments, and I think it's a good rule. Thank you.
Thank you, Commissioner Chilton. Commissioner Amalia.
Thank you, Mr. Chairman. Thanks to the team. Great hard work on this. I know you guys have labored just to explain it to us, so that's been no easy task. Let me ask you some questions. Will end users have to post initial and variation margin to dealers? That's a margin-related question. We think we understand what that one would be.
And I believe it's pursuant to the credit support agreement that they enter into.
Yep, agreed. If an end user does not post initial and variation margin to a swap dealer on a swap it enters into with a dealer, then will that swap dealer have to take a risk-based capital charge for that swap?
Yes, if they don't have collateral, yes.
If the end user posts initial and variation margin to a swap dealer, will the dealer have to take a risk-based capital charge for that swap if they post margin?
If the margin covers the extent of the exposure, no. If the margin is not sufficient, yes.
And what is that exposure?
The current exposure and the
risk,
potential future, yes.
The risk-based capital charge?
Yes.
Okay. So it's commission's policy to make, so they're either going to have to pay a capital charge or going to have to pay margin.
If there is no margin collected or posted by any end user, and if you want to limit it to commercial end user with a dealer, they will have a charge in their credit risk charge. Yes, they will.
Okay, I think that's what I said. All right, thank you. So how does that comply with the Lincoln Dodd letter that said, Congress clearly stated in this bill that the margin and capital requirements are not to be imposed on end users, nor can regulators require clearing for end users? How have you taken that into consideration in this rule?
I think one of the things that we're doing is looking at it from the full perspective of what are these swap dealers allowed to count as their capital. And this rule looks at those swap dealers that are dealing with the commercial end users, except if they're a financial company, in a very broad way, and allowing them to use a significant amount of their assets to meet that capital requirement. So it's sort of a balancing of capital and the margin requirements.
Okay, I appreciate the flexibility you've created with this tangible net equity. However, to your point, to the question you answered previously, was if they don't post margin, they're going to post a capital charge, right?
They're going to incur a capital charge because we're required to impose capital requirements on swap dealers and end users.
This is getting circular, but how did you account? No, we won't go there. Back to the Dodd-Lincoln letter. All right, moving on to credit rating issues. How do you treat the credit worthiness of counterparties when you apply a credit risk factor charge? If you could explain what that rule provides for.
Yes, and in computing the extent of the credit risk exposure, first you look at what is your current exposure to a counterparty, which is the mark-to-market of the positions, and you also look at potential future exposure. At that point, under the Basel standardized approach, you assign a factor to that, which would be either 20%, 50%, or 150%, depending upon the credit rating of that counterparty. What we had proposed in this rule is to just use a 50% standard, and not, or we have a provision in there that would allow the swap dealer to internally develop what those credit ratings are, and they would seek commission approval or review of those rating approach. And then the resultant number would be 4%. So whatever it comes out to, 4% is the credit risk charge.
Now I'm confused. 4% or 50%?
It's 8%. So it's 50%. You look at what your current exposure is and your potential future exposure, add those together, apply this charge, which is 50%.
So it's a 50% haircut.
No, it's not a 50% haircut. There's one more step to the equation. Then the haircut is 8% of that. So it effectively comes down 50% of 8% is a 4% charge on your current and potential future exposures, the aggregate of those. So that would be what a swap dealer would have to have a capital reserve for from credit risk.
My question was the credit risk factor charge. What are we assessing? Because I understand there's the Basel standard and there's this 50% standard for how you you compute this, and I know we had been discussing back and forth whether we were going to apply the straight 50% haircut for the initial evaluation as opposed to the Basel that uses credit ratings
Right.
to some extent.
That's right. That's
So
right.
let me just deal with that part of it
Okay.
before we move on to this
Okay.
4 or 8%.
Yep.
So in the rule, it's 50% straight.
Correct.
Regardless of your credit quality.
That, unless you generate that internally within
The swap dealer?
Yes.
Okay. And the Basel standard, which is what we've used throughout this rule up until this point, is 20% for investment grade, so it's a 20% haircut, 50% for junk, and 150% for distressed.
For anything else.
For anything else, right?
Yes.
Okay. Now, did we ever, I know we discussed about changing whether we were going to use credit rating agencies for company credit quality. I know the statute says not for securities, but it doesn't say that we can't use it for companies.
No, right now it's stayed at 50%.
Right, and we just ignore the other. Now, what if a swap dealer comes up with a model that says, we're actually using credit rating agencies to evaluate the quality of our counterparty and are basing our standard on that? Will we accept it or not?
We'd have to look at what the whole program is. I don't know at this point in time.
Okay,
It'd be
well,
part of it.
I have a serious concern about treating everybody with this 50% rule, and I know you're probably trying to avoid using credit rating agencies, but
Yes.
that's what Basel allows for, and we use Basel throughout this entire rule, other than this factor here. So I'm a little confused with that. Let me go on to collateral. There's some language about, it's in the swap dealer's physical possession or control. Does that mean an oil field? If you post that as collateral, do you physically have to, is it take title to it, or?
I think to qualify as collateral, it would have to have some kind of, you wouldn't want the collateral being used in multiple instances or for multiple obligations. So generally speaking, there is either a lien or there is some kind of mechanism to ensure that that collateral is unencumbered.
But is physical the right word for that?
It can be, and I think
Okay.
we use that in the FCM concept where they often post treasuries and other things with an FCM. So it's borrowing from that concept. It doesn't have to be in the possession, but it needs to be in the possession or control or have some kind of lien.
There's a new provision that came in late. This conforming, on page 63, conforming amendments to delegated authority provisions. This seems to be an amendment to our margin rule in some respects. Not in some respects, with regard to the margin rule, I think it is an amendment to our margin rule. Is that correct? Page 160, page 64 and 65.
I think, yeah, what those are there's existing delegations in Regulation 140.91. What we were proposing in this rule was to, where certain authorities are delegated to the commission by the rules, or under the authority of the commissions, they have delegated certain responsibilities to the director of the Division of Clearing and Intermediary Oversight. So we're picking those up. The ones for the margin were in the proposed margin rules with respect to what the rules were and what the commission's authorities were. But the provisions to incorporate the delegation to the Division of Clearing and Intermediary Oversight Director was not included in that rule. So we picked them up here. But then we're not changing the rules that were put out for proposal by the commission with respect to margin. It's the delegation of certain authorities to the division director.
Okay. In this, on the margin rule, we had an extensive discussion of modeling margin with Ananda. It was at the table. And it was Ananda's belief that we we just had to accept these models, and we weren't, especially for the 716 pushouts. Now, I know, and he said he didn't have the resources to evaluate the models. Now, I read this, and it says, it contemplates DCIO being able to basically consider what's acceptable margin and what's not, and make changes to individual assets or collateral. If we don't have the capability to approve the models, how are we going to evaluate everybody's individual collateral and assets that they're posting? How do we get into that? How are we going to have the resources to do that?
I think the concept was that you might have a case where something becomes a distressed asset, and we become aware of something that was fine, was posted as collateral, and because of something happens to the issuer, we become aware of it, we might go into the registered entities or registrants and say, we don't think that this is acceptable now. It fit before, but in the news, it becomes a distressed asset, and people across the markets are haircutting these things dramatically.
So we would say they can't haircut them as drastically?
No, if somebody was not, for example, if somebody was
Oh.
giving full value to something that we believe should now be haircut.
Is this kind of a one-way street that if they're only overvaluing them, what if they're undervaluing them?
Yeah, I don't think that we would contemplate if somebody was, I'm sorry, maybe I misunderstood the question to you.
Well, this whole rule seems to say that, we can replace we can require an entity to replace a margin asset posted with a CSE, which is a swap dealer, major swap participant, with a different margin asset. It says we can require a CSE to modify the margin haircut. And I'm just trying to say, what is our role here? How much interference are we going to have in this? And how often are we going to look at this, and what are the criteria? I have a lot of questions about this one, and I'm trying to understand. Would it be both ways? If it's too low, we would say, the calculation's higher. If it's too high, say it's too low.
Again, I think that we're thinking it's in the direction where something is now, we believe, overvalued, and therefore putting the entity at risk because they're accepting something or valuing something in a way that is not appropriate anymore. And again, I think the notion for delegated authority is this could be in a distressed market situation. Perhaps not only is the collateral in a distressed situation, perhaps the individual dealer is in a distressed situation, and so we want to be able to act quickly.
Well, since we've authorized this vast authority without much limitation, can I talk you into maybe creating some thresholds or some flexibility on end user capital requirements? Maybe substituting our decision for what a bank may assess a small end user? Would you be interested in that? Silence is deafening. I think there's a typo in this on page 65, the second line. The commission is proposing to delegate authority with respect to blah, 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 which would authorize the commission. Don't you mean the commission is not delegating, the commission's delegating DCIO? Line 2, page 65. Is there any objection to fixing that typo?
Unanimous consent to fix the typo. No objection, it's fixed. Good catch.
I read this stuff. I have no further questions, thank you.
I thought I'd reply to a question you gave the staff, how I comport with the Dodd-Frank letter. Not the Lincoln Dodd letter is, this rule does not impose a charge on the end users. I do appreciate that end users doing swaps with a bank, where the federal prudential regulators are setting capital, or doing it with a non-bank where the SEC or we're doing capital, that capital is priced into the swap, but there's no capital being assessed or imposed directly on the end user. It's part of that business. So as it relates to the letter itself, I think, and I know we have a difference here, but I mean, I think that it does comply with that letter. We're not doing margin. That's the rule we did 2 weeks ago. Congress said they're not having clearing. That's all right, too. And on capital, I think the capital that the dealer has to have, we've taken a very balanced, my worry might even be light approach, but they're not systemically relevant because they're not SIFIs and they're not part of bank holding companies. So I think this tangible net equity approach where they could be using the factory for other reasons. And the handful of people that have been in have said, if we don't have to segregate it and we can use tangible net equity so we can use the factory for other purposes, we think that that might work. Might. They'll see the proposal and then they'll comment. So, but
Thank you for clarifying that.
Mr. Staywick.
Commissioner O'Malia?
Nope.
Commissioner O'Malia, no. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
I thank you, and we'll accept that vote, and along with the others, be forwarding to the Federal Register. Let me just see whether I'm supposed to now, or there is this vote on extending the other comment period. Am I going to do that now? All right, I'm supposed to just read. As we noted 2 weeks ago when the Commission proposed the margin rule, it's our intention to ensure that the comment periods for proposed margin and capital rules end on the same date. To that end, consistent with the draft Federal Register release that the Office of the General Counsel circulated, do I hear a motion to extend the comment period for the proposed margin rule to end the same day as the comment period for the proposed capital rule that we just considered?
Mr. Chairman, I have an amendment I'd like to offer to this, if I may. I have an amendment, and if it's appropriate now, then I'd like to do it now. If we
This
need
is
to.
just to the, this is not the 30-day piece.
Oh, okay.
This is just the, this is just to make margin and capital coterminous.
No complaints.
Okay. Do I hear a motion?
So moved.
Second.
If there's no discussion, Mr. Staywick, could you call the roll?
Commissioner O'Malia?
Aye.
Commissioner O'Malia, aye. Commissioner Chilton?
Aye.
Commissioner Chilton, aye. Commissioner Summers?
Aye.
Commissioner Summers, aye. Commissioner Dunn?
Aye.
Commissioner Dunn, aye. Mr. Chairman?
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 5, the nays are 0.
Okay, thank you. We will have a separate vote after the fourth one on this whole 30-day concept. Thank you so much, Thelma, Tom. John, you get to stay at the table, I think, right? Changing seats. I did notice a bunch of other alums here, you know, Jim Newsom, Brad Berry. I mean, I noted David, and there's so many people here, so I didn't want to leave you out. And there's probably Graham. I mean, there's too many, but there's a lot of. Dan Wadman comes back every time. Allison, there's Allison Lord. There's probably people I'm just not seeing, and my eyes are blurry. John Lawton, Peter Cowles from the Division of Clearing and Intermediary Oversight. There's Nadia. Division of Market Oversight, David. Back at the table again. From the General Counsel will present the staff report on proposed rules concerning amendments to adapt certain CFTC regulations to Dodd-Frank. I don't know who I'm turning to, but the team.
Okay. Good afternoon. The Commission has before it amendments to numerous regulations across its rule book to bring them into conformance with the requirements of the Dodd-Frank Act. In some cases, the changes are purely ministerial. For example, deleting references to derivative transaction execution facilities, a category of trading platform that was eliminated by Dodd-Frank. In other cases, the changes, while technical, did require the exercise of a judgment in drafting, for example, modifying various definitions to accommodate swaps in the rule book. Finally, in several instances, the changes are substantive in nature, for example, modifying certain record-keeping requirements and aligning them across futures and swaps. With regard to the cost to the staff believes that implementation of these particular rules would actually not require additional resources. Staff believes, in fact, that by clarifying and harmonizing various rules across the rule book, that should facilitate oversight of the markets and reduce the need for interpretive guidance going forward. To provide a bit more detail, I'm going to turn it over to my colleagues. First, Peter Kells of DCIO, then Nadia Zakir of DMO, and then finally Dave Aaron of OGC.
The Dodd-Frank Act amended the Commodity Exchange Act's definitions of futures commission merchant and introducing broker to permit them to trade swaps for customers. Accordingly, the proposed rulemaking amends regulations applicable to FCMs and IBs so that they cover swaps analogously to futures. Definitions. Staff has proposed revising the definitions of customer, customer funds, and commodity interest so that customers of FCMs and IBs include swap customers, and so that the transactions they handle include swaps transactions in addition to futures transactions. Record keeping. We've proposed revising fundamental record-keeping rules so that FCMs and IBs keep records of swaps transactions similarly to how they presently maintain records of futures transactions. For example, we've proposed amending Regulation 1.31 so that swap records must be maintained not only for 5 years, which is the current retention period for futures records, but also for the life of the swap, because swaps tend to have longer terms than futures. This would require FCMs and IBs to maintain swap records for the same amount of time as the Commission recently proposed for swap dealers and major swap participants. Bunched orders. Under current Regulation 1.35, FCMs and IBs must keep records identifying each customer whose order is submitted to a designated contract market. However, if an FCM or IB receives several orders for the same contract, a bunched order, from an eligible account manager, such as a commodity trading advisor, the FCM or IB need not include in its trading records the identity of each customer. In order for the FCM or IB to avail itself of this exception, the eligible account manager's post-trade allocation scheme must be fair so that the manager doesn't give preferential treatment to certain customers if the FCM or IB can't fill all of the bunched orders at the best available market price. Staff has proposed amending the bunched orders provision so that swap orders can be bunched analogously to futures orders and can be submitted to a swap execution facility in addition to a DCM. Staff has proposed provisions specific to bunched orders for swaps executed bilaterally, whereas eligible account managers must allocate bunched orders that have been cleared as soon as necessary to ensure that clearing records identify each customer, which would have to happen sometime before the end of the day on which the order is executed. Bunch orders executed bilaterally must be allocated to individual customers by the end of the day on which the order was executed. The preamble of the proposed rule seeks comment whether it would be possible for market participants to bunch swap orders as proposed. Finally, in amending the bunch orders provisions in Regulation 1.35, staff has proposed adding FCMs and IBs to the list of eligible account managers. We understand that these brokers have the ability to bunch orders, and therefore they should be permitted to do so, provided they comply with all of the existing rules, as well as other regulations that prohibit these brokers from trading ahead of their customers. As a result, FCMs and IBs would not be able to bunch customer orders with their own proprietary orders.
Good morning, Mr. Chairman and Commissioners. In addition to establishing a comprehensive regulatory framework for swaps and security-based swaps, Title VII of the Dodd-Frank Act also created a new type of regulated marketplace and registered entity called the Swap Execution Facility, or SEF. The Dodd-Frank Act established a new regulatory framework for SEFs, similar in many respects to the regulatory framework for designated contract markets. In particular, the regulatory framework for SEFs under the Dodd-Frank Act includes a number of self-regulatory responsibilities that are similar to the self-regulatory obligations of DCMs. Accordingly, the amendments to the Commission's regulations proposed today would add CEFs to certain regulations that currently apply to designated contract markets. As an initial matter, staff is proposing to amend the definition of self-regulatory organization in Regulation 1.3EE to include CEFs. The addition of swap execution facilities to the self-regulatory organization definition would, for example, require CEFs to comply with Regulation 1.59, which requires self-regulatory organizations to submit rules to the Commission that prohibit certain conduct by their employees. Staff also is proposing several new and revised definitions under Part 1 for terms that are newly defined or have revised definitions under the Dodd-Frank Act. Such terms include swap execution facility, swap data repository, floor broker, and floor trader, to name a few. Staff is proposing also to amend Regulation 1.35 to add CEF participants who have trading privileges to the list of persons that must comply with the basic record-keeping functions that are currently applicable to members of designated contract markets, FCMs, intermediary brokers, and retail foreign exchange dealers. The proposed revisions to Regulation 1.39 would extend the requirements applicable to the simultaneous execution of buy and sell orders of different principals to CEF participants with trading privileges. Staff also is proposing to extend Regulation 1.67, which currently applies to designated contract markets, to CEFs, thereby requiring a CEF to notify an FCM or other registrant upon learning that a member of such facility or market violated a rule resulting in financial harm to a customer, and requiring the FCM or registrant to then notify the customer. Staff is further proposing to revise Part 7, which currently sets forth contract market rules altered or supplemented by the Commission pursuant to Section 8A7 of the Commodity Exchange Act. Staff proposes to revise Part 7 to include the rules of any registered entity, including CEFs, that the Commission may alter or supplement in the future. In order to implement the grandfathering and phase-out of exempt markets under the Dodd-Frank Act, staff also is proposing amendments to Part 36 governing exempt markets. The revisions eliminate cross-references to sections of the Commodity Exchange Act that are eliminated by the Dodd-Frank Act. While eliminating the cross-references, the proposed revisions incorporate the relevant substantive provisions of the Commodity Exchange Act applicable to exempt markets that will continue to operate during the pendency of the grandfathering period as permitted by the Dodd-Frank Act. Finally, staff is proposing revisions to Part 140 and 145 pertaining to governing organizations, functions, and Commission procedures, and Commission records and information. The proposed revisions largely add CEFs and swap data repositories to the provisions that are currently applicable to other registered entities, including, for example, the Commission's delegation of authority to divisions within the Commission to publish in the Federal Register and to disclose confidential information. This concludes my presentation, and I look forward to answering your questions. Thank you.
I just have a few preliminary remarks. I just want to say it's great to be back here. It's even more fun the second time around at the agency. And Peter stole one or two of my bullets, so my presentation will be even shorter than it otherwise was. And lastly, I didn't actually draft the proposed changes to 1.31 and 1.35, so my able enforcement colleagues may jump in response to some questions that I anticipate on possibly the oral record keeping rule and otherwise. So 1.31 is the Commission's general record keeping rule. 1.35 is the transaction record keeping rule. Our general approach in what we're recommending today was to conform to the December 9th swap dealer and MSP record keeping rule, which I note was a 5-0 vote, to conform in some respects to international standards. 1.3, the overview of the 1.31 changes are first that all persons who are subject to our record keeping rules would be required to keep those records in original format for paper or native file format for electronic records, and I'll come back to what native file format means in a minute. And I understand that enforcement already expresses a preference for those formats in their record production requests currently, so it won't be a complete surprise or change. The production of records must be in a form we're proposing or recommending that you propose that they be in a form specified by the Commission, and Federal Rules of Civil Procedure already require that with respect to federal proceedings currently. Next, we would propose that record keepers maintain records of swaps and related spot and forward trades until, as Peter mentioned, till expiration, termination, or transfer plus 5 years for the reasons Peter mentioned. And lastly, the record keepers would be required to permit inspection not only by us and DOJ, but also the applicable bank regulator or regulators, and for security-based swap agreements only the SEC. So native file format briefly is the format in which the electronic file was originally created. And this is important because saving a file in that format ensures it will store all the data that were created with the program. Other formats may be compatible, but they might not save all the information. So if you save a Word document as a plain text file, it removes the formatting. We don't want changes like that. So moving to 1.35, the record-keeping obligations would extend to, I think Peter mentioned this as well, swaps executed by FCMs, IBs, and CEF members on CEFs. The rule applies now to non-swaps and only on DCMs. Next, the oral record-keeping proposal, it would expressly require FCMs, retail Forex dealers, IBs, and DCM CEF members to keep records of all oral and written communications that lead to commodity interest or cash commodity trades, commodity interest, swaps, futures options, commodity options. And the rationale behind our recommendation is that where oral communications are used to form trades, the Commission has historically had a more difficult time enforcing the Commodity Exchange Act and our regs, and particularly where we must establish a threshold knowledge or intent level of sustained inaction. And as a consequence, enforcement success is often directly correlated to the existence of high-quality voice recordings. So we're trying to increase the efficiency and get better results. So that's kind of a quick and dirty, and ready for some questions.
With that, the chair will entertain a motion to accept the staff recommendation to issue the rule concerning amendments to various regulations.
So moved.
Second?
I have just a couple questions. I support this, but I particularly want to ask a question about bunched orders and then maybe on this record keeping. And again, I'm relating this because so many meetings that I've been in, asset managers, particularly asset managers who use sub-accounts. A sub-account might mean that they're managing for many different pension funds money, have raised the bunched order flexibility that they have in the futures world and have asked that they have a similar flexibility in the swaps world if they're traded on a swap execution facility or brought to a clearinghouse. So my question, Peter and John and the team, is, do you think this addresses, and I know, John, you've been in some of these meetings, does this address the issue that many of these asset managers have raised?
Yeah, we believe that it does. We've talked to a number of people, and I think the people are certainly interested in reviewing this and seeing whether they believe it can work for them. And I think it ties to the Part 39 straight-through processing rule that the Commission proposed recently, that asset managers had a concern about that rule because they don't necessarily know at the time a trade is executed who is the ultimate beneficial owner of all the pieces of the trade. And we believe that issue was raised in the futures world in the past, and that the bunched orders rule seems to address it, and we're trying to establish an analogous procedure for swaps.
So, I mean, we could get into debate whether this is a conforming rule or not a conforming rule. It's not ministerial, as you said, but it is, in essence, taking, is it 1.35 as it applies to futures and allowing basically the flexibility that these pension funds and asset managers could use a similar approach to swaps?
Right, and I think that one issue that people will discuss is what should be the deadline for getting your allocation done, and I think we'll get some comment on that because it may be that different asset managers have different capabilities as to how quickly they can do it.
So I think this is, I think this helps lower risk to the market as it brings things into clearing and swap execution facilities, but actually addresses a legitimate concern that asset managers said without clarifying it, because if the commission didn't clarify it, do our bunched order rules for futures apply to swaps? And this is what this proposal's saying.
Essentially, yes.
Yeah. And then on record keeping and reporting, I guess David, and maybe I see Vince there as well from the Division of Enforcement. You said that this is, again, you know, whether it's not ministerial, whether it's conforming, but in any event, this is consistent with what we did in a rule in the fall, proposed rule in the fall, for swap dealers, record keeping. Is that correct?
It is actually, isn't it? The oral.
Vince,
Right.
come up to the table if you want.
Right, there was one of the business conduct rules for swap dealers had a similar provision, and so that it's proposed, it's out there as a proposal for swap dealers and MSPs, so this would apply a similar requirement to FCMs and IBs.
Is that right?
Yeah, that's right. And so it captures language that says each transaction record shall be maintained as a separate file, identifiable by transaction and counterparty, as well as the length of time, say in particular for audio, which is new proposal for 135, that it be for 5 years. And so currently, this proposal tracks the prior language that was used for the swaps rule.
And it's still, you know, it was out for comment, but if we do vote in a few minutes to extend everybody 30 days, that would be extended as well, so it would be helpful. Do you know what the international regulators do, the FSA, for instance? What do they do in this area?
So with respect to audio recordings, there's been conversation in the regulatory community, even internally within CFTC, for several years about whether their record-keeping obligation should extend to audio. And commencing in 2008, the UK FSA commenced a comprehensive market study with respect to audio requirements and imposed a rule that had a retention requirement of 6 months that was basically focused on communications, say, at certain dealers, that those communications be maintained for a period of 6 months, and entertained a number of comments from various industry sources in determining whether to roll out that rule. Had a very long tail with respect to the implementation. The proposal was out there for several months, and then when the proposal was picked up, implementation period extended thereafter for several months. But the FSA takeaway was that in large part for their community, audio was already being captured. And so to the extent that for the large firms, they were already doing it, the FSA didn't see that there was large additional costs imposed. That's not to say, however, that those commenters who submitted letters to UK FSA agreed. I mean, they took the position that there would be costs associated with respect to audio requirements. The UK FSA ultimately disagreed in terms of whether the cost should outweigh the benefit, and ultimately promulgating the rule. And the UK FSA is also coming out with a new proposal which will be effective in the fall with respect to cell phone communications and the data capture for those conversations.
And is it correct, I gather this, from the Division of Enforcement, you're recommending this for at least two reasons. One, it makes futures commission merchants have to be consistent with swap dealers. Is that?
That's correct, Mr. Chairman.
And then the second reason is you think it would be facilitate this agency's transparency and ability to police the markets?
So the benefits that we see for market protection, deterrence, the communications, we're neutral as to the communication, so they may be inculpatory or exculpatory. But the fact of the matter is that people communicate about their transactions through writing and orally. We have a very good program in place for the capture of written records, written communications, and this would capture oral communications that relate to the transactions that we're most interested in.
Okay. Thanks. Commissioner Dunn?
Let me follow up on that because, correct me, if the proposed rule regarding oral communications requires that a registrant would actually record all oral communications, that could lead to an executed transaction. Is that correct?
Yes, Commissioner, the operative language is all oral and written communications provided or received concerning quotes, solicitations, bids, offers, instructions, trading, and prices that lead to the execution of transactions in a commodity interest or cash commodity, whether communicated by telephone, voicemail, facsimile, instant messaging, chat rooms, electronic mail, mobile device, or other digital or electronic media.
Well, I'm on the oral side. I wonder, when does the tape have to go on? I'm in Chicago, so naturally I'm going to give a little push for the Bulls since they won last night. Say you called up your friend and you started talking about the Bulls game last night, and that evolved into something that potentially leads to a transaction. At what point do they have to turn on the tape, or is it supposed to be on all the time?
So my first answer is the conservative one, which is basically, I'm interested in comments. We'll be interested in comments concerning how people are already taping in the community. My expectation is that the tape's going to be running. And in a number of cases where we've obtained audio recordings, it's because people are speaking on a tape line. And so they're having a conversation at a desk where they're most likely to be conducting business that's relevant to our jurisdiction. So I think it's a situation where they would not be able to toggle on and off during their communication, that it would capture for the entirety of the day those individuals that are engaged in transactions that would be subject. So, we do pick up conversations, and this has happened in the past, where people will say whatever they say on the phone, some of which won't be susceptible or privacy issues or talking about their day-to-day life, and intermixed with that will be transactions or communications about transactions. So that's a long way of saying that I don't know that finding a bright line will be easy to do. It would be easier, I think, if you had a tape line and people conducting business just conducted their business on that tape line.
I could just add a little something in connection with the FSA study. They found that 80% of the covered phone lines were already being recorded, and it's not that unusual on Wall Street for the traders to be recorded. You often hear the beep in the background when you're talking to a trader. So we'll find out in response, to what the commenters say, if maybe it's changed, but it shouldn't be all that unusual.
All right, thank you.
Thank you, Commissioner Dunn. Commissioner Summers?
Thank you, Mr. Chairman. I don't have any questions, but just want to state 2 objections to these conforming amendments. The first being that I think it's premature to have conforming amendments to conform to proposals that we haven't finalized yet. And the second one is the inclusion of issues that I believe are important issues, but substantive issues being put into a proposal that is supposed to be conforming. I don't have any questions. Thank you.
Thank you, Commissioner Summers. Commissioner Chilton?
I have no questions to support it. Thank you.
Thank you, Commissioner Chilton. Commissioner Malia?
On the recording and the record keeping, the amendment would require that recorded communications be identified by counterparty and transaction. How does this differ from current storage practices of electronic communications? And the second part is, can this kind of tagging be accomplished automatically, without human intervention? So, we're not going to have to sort this thing out.
I'm not really sure about the technology, but obviously when you just set your phone line to be recorded, it will all be there, and presumably, just manually it could be done by simply somebody stating at the beginning of a conversation who they're talking to. I don't know if we thought about that specifically, but just off the top of my head.
Well, this goes to kind of the larger conforming to our other major rulemakings about counterparty IDs and legal entity identifiers. If we're going to try to sort all these communications out by those transactions, we're going to have a way to manage that without saying, speaking into the phone line and then requiring us to sort that out. That's not a winner for us. Does anybody have any thoughts on that? How we're going to sort that out, or how they're going to sort that out so we don't have to?
Certainly, the industry that is using audio now, they're capturing the information in a way that is somewhat searchable because they want to go back and confirm the nature of the transaction. So, it's, from our enforcement's perspective, our ability to do the audit trail without, to focus on communications of interest and filter out those communications that we're not interested in is important. But I think here, in particular, as it relates to audio, how those communications are tagged by transaction and counterparty will be a key area for comment, so we can see what people are able to do currently for their audit trail as it relates to audio communications, because I think it's different for the electronic, the email and chat rooms, things like that.
Also, if I may add, some market participants have already commented on some of your questions with respect to the swap dealer record-keeping rule, and I know generally that staff is considering those comments already.
Can you characterize those for me?
I don't have specifics about those.
All right.
I do know, Commissioner Valle, I asked just back here, there's about 20 comments on that original rule, but no summary of it.
Mr. Chairman?
Yep.
Mr. Chairman?
Yes.
Just to follow up on Commissioner Summers' comments, will this comment be held open until all other rules are completed?
Well, I think this would be held open for the 60 days, but it's not my anticipation that any of us are going to be thinking about this is going to be an early rule we finalize. So just like we have discretion to consider late comments, as late comments come on this, we'd have the discretion to take those comments in.
Thank you for that clarification.
Mr. Stawick?
Commissioner O'Malley.
Aye.
Commissioner O'Malley, aye. Commissioner Chilton.
Aye.
Commissioner Chilton, aye. Commissioner Summers.
No.
Commissioner Summers, no. Commissioner Dunn.
Aye.
Commissioner Dunn, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
The ayes have it, so the staff recommendation is accepted. I do ask at this point for unanimous consent to allow staff to make technical corrections to the documents voted on today prior to sending them to the Federal Register. I guess not hearing any objections, the technical corrections are done. As I noted when we opened the meeting, we have now substantially completed the proposal phase of our Dodd-Frank rule making. We do have the Volcker rule. We're bound to find some other things that we'll think are appropriate to propose. Testing and supervision, we've had a lot of discussions, and I'm very much looking forward to staff recommendations on that.
What about portfolio margining?
I'm with you on that one. Commissioner O'Malley and I have been like,
let's write one.
Yeah, terrific. We need to work on that one. So I agree with Commissioner O'Malley on that. But to continue to give potential market participants the opportunity to evaluate the entire mosaic of rulemakings, the Commission will vote to reopen and extend a comment period. I know Commissioner O'Malley has an amendment to what's been circulated here, but let me say, I think this time will allow the public to submit any comments they might have after seeing the whole mosaic. And for the rules which the comment period is closed, we've had the discretion. Those late filers have been put up on our website and so forth, but this is a more formal way to say, in essence, take the month of May and have people reflect and comment on these things. but before, I think I need to have a motion on extending the period for 30 days, and then Commissioner O'Malley could do the amendment. But do I hear a motion first on the Federal Register release that was distributed around to the commissioners' offices?
So moved.
Maybe I'll second it. So, and then I know that you had an amendment that you wanted to make.
Mr. Chairman, I move to amend the proposed rule by inserting language in the summary dates and supplementary information sections that would request comment on the proposed sequencing of considering final rules promulgated under Dodd-Frank. I have circulated a draft that includes that language. Now, Mr. Chairman, we had talked about earlier on today about a more specific proposal. Now, thanks to questioning by Commissioner Summers and Commissioner Chilton and Dan, our General Counsel Berkowitz's answers, I have found a solution that will not force everyone to take the proposal, the very specific rulemaking proposal that I was seeking comment on, but I can submit that as part of as part of my comments as an amendment to the rule. So I'm only asking that the language simply says the Commission is also requesting comment on the order in which it should consider the final rulemaking made under the Dodd-Frank Act. Now, I will, in my concurring statement, put forward a very specific list that wouldn't have passed because under the short time frame, I don't think I'd given enough time for our commissioners to review that. So I will put forward that. I will hope that the public will comment on that proposal and make suggestions based on that, and if it's completely wrong, I won't be offended. But we would like to have the public's input, the market's input as to what the proposed sequencing going forward is while we have this extra 30 days or so to develop this rulemaking. This does not at all satisfy my other concern that we ought to also put forward an implementation schedule and put that to the comment so the public can comment on that. I think making full transparency of how we're going to implement these over what period of time will be essential to developing budgets, developing priorities, and hiring, et cetera. So I guess I'm scratching one part of the itch, but I'll be back. So I appreciate the Commission's tolerance of my amendment at this late date, and I appreciate the willingness of staff to kind of work this out as well.
It'd be my honor to second your
Thank you. I appreciate
amendment. The original proposal being moved and seconded, and the amendment moved and seconded. Are there questions for Commissioner O'Malley on his amendment, or any comments by commissioners? I want to talk about implementation phasing, but it's not a question. So I just want to see Commissioner Chilton or Commissioner Dunn, who are in Chicago.
Well, I have some questions, Mr. Chairman, but perhaps I want to hear your comments first.
Okay. All right. So on implementation phasing, I think we've benefited by that all of our rules have asked about effective dates, and we benefit that Congress has actually given the SEC and CFTC some flexibility on effective dates. The staff is having a roundtable, 2 days of roundtables next week. It's our anticipation that before the roundtables, they're going to put out a set of concepts, whether there'll be 10 or 12 or 14 concepts. It's still sort of in discussion with the SEC. These will be at the staff level. They don't implicate the 5 of us or their 5 commissioners, and I think it will be very helpful to get the public comment on these dozen or so concepts and get those questions out. We have a public comment file that I think is open until June 10th or something as well. Implementation phasing is a very important role that we play to help lower the cost, to get the job done, as Congress has asked us, but try to take that cumulative cost and sort of phase it over time. When does a clearinghouse sort of be open for business, have its rule book in place? When does a SAF or a swap data repository sort of be open for business and have its rule books in place? Can be different than, for instance, when the clearing mandate actually takes place and so forth. So I think that we'll get a tremendous amount of public input through putting out these what I'll call concepts, getting the input next week. No doubt The concepts will change. We'll all deliberate a bunch and continue to get the good feedback from the public. I think this specifically about how we phase our final rulemaking, it is helpful to hear from the public, but a lot of that, I think, is going to be when the staff can adequately summarize the comments, when we have sufficient time to deliberate, and of course, when we consult with other regulators. And I think that there's some rules that, frankly, we'll be able to move sooner because they're less controversial. But we still might say the effective date is 6 months or 9 months later, or it might be an effective date that's conditional upon another rule being finalized. So I wouldn't want to be constrained if we happen to have consensus and we can move a final rule, because that helps lower market uncertainty, even if we delay the effective date. I look at the two can be detached. So, but I turn it to Commissioner Chilton because I thought you had something you wanted to add, and I didn't want to front run what I thought you wanted to add.
Well, no, actually, that was helpful hearing what you were saying, Mr. Chairman. But I did have a question then in that same line for Mr. Berkovitz. Nothing in the original 30-day comment period, which enumerated several rules, there's nothing in that language that would require us to extend the comment period on rules that are not enumerated. Is that correct?
That's correct, Commissioner. Only the specific rules that are enumerated in the Federal Register notice would the comment period be officially reopened or extended.
Okay. And then the second question, because I generally think that this idea of sequencing that the chairman talked about in February and Commissioner O'Malley is trying to move forward is a good thing in concept. I had significant problems with the original amendment that Commissioner O'Malley had, but the concept I think is a good one, and I don't want to mess that concept up. So my question, Mr. Berkovitz, is what essentially the chairman I think was saying there, but just to confirm, there is nothing in the language of Commissioner O'Malley's that would restrict the commission from implementing or passing final rules that are within the constructs of the Act. Is that correct? Nothing with, let me say it again, nothing within Commissioner O'Malley's language would restrict the Commission's ability to operate within the constructs and timetables of the Act. That doesn't mean we're going to meet all the deadlines. We've talked about how we're not. But I just want to ensure that just because we're asking for the sequencing, that as the chairman suggests, if we have the wherewithal with a number of votes to go forward on something, we're not required to wait for these things. We can still do what Congress told us to do. Is that correct?
Commissioner Chilton, Mr. Berkovitz is just making sure he had seen the language, but with your question, he just wants to refresh his look.
That's fine with me. We want to be sure. We want to be deliberate.
That's correct, Commissioner. The amendment would not restrict the Commission's discretion or ability in terms of the sequence of the final rules. This notice would not do that.
Okay. Well, I think it's a helpful thing, Commissioner O'Malley, in general. Again, how you've amended your amendment, I think it's helpful. I don't have any other questions, Mr. Chairman.
Mr. Chairman, I've got a question, and it's a follow-up on Commissioner Summers' concern about legal certainty in the swaps with the repeal of certain provisions of the Commodity Futures Modernization Act. Will we address that particular concern?
Commissioner Dunn, I'm going to hand it over to Dan Berkovitz, but it is my hope that we would, that the five of us, through our staffs and through our good counsel of our general counsel, but as well as the heads of the Division of Market Oversight and heads of DCIO, have some recommendations The issue before us, and Dan, if you can comment, is that under Dodd-Frank on July 15th, I think it's exactly in 12 weeks and 1 day or so, that there's certain self-executing provisions of Dodd-Frank. And as we move through our rule writing in the summer and what will be into the fall to finalize rules, how the market addresses that. So it's my hope that we'd have recommendations from staff and we would address ourselves to it. But Dan, do you want to take the question?
Yeah, that's correct, Mr. Chairman. The staff in my office, in General Counsel's office, and in the divisions have been working to look at the various requirements which would come into effect and the provisions that in existing law which would no longer be in effect as of the effective date, and to prepare a briefing for the Commission and the options and our authorities for addressing that. We'd be prepared to brief the Commission on that shortly.
The emphasis was on shortly, right, Dan?
Very shortly, Mr. Chairman, yes.
Not hearing any further questions. Mr. Stawick, you'll have to figure out how to call the roll, or do I?
You may do it by a voice vote, Mr. Chairman.
I'm allowed to do it by voice vote. All right. So, do I do a voice vote on the amendment first?
Yes.
All right. So, if I could have all those in favor of Commissioner Amalia's amendment, say aye.
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 Those opposed to Commissioner Amalia's amendment?
No.
The ayes appear to have it. And now I'll move to the amended motion on the 30-day extension. All those who are in favor say aye.
This one, Mr. Chairman, I
Oh,
think
this is a recorded vote?
This is
Recorded.
the action, so under the previous unanimous consent
All
request.
right, so Mr. Stawick, will you call the roll on the amended motion?
Commissioner O'Malia.
Aye.
Commissioner O'Malia, aye. Commissioner Chilton.
Aye.
Commissioner Chilton, aye. Commissioner Summers.
No.
Commissioner Summers, no. Commissioner Dunn.
Aye.
Commissioner Dunn, aye. Mr. Chairman.
Aye.
Mr. Chairman, aye. Mr. Chairman, on this question, the yeas are 4, the nays are 1.
Thank you, Mr. Stawick. The ayes having it, that too will be sent to the Federal Register. Throughout the summer and into the fall, the Commission will hold meetings like this one on some regular basis, but we haven't set a schedule yet as we work through some final rules. Right now, we sort of have a bit of a natural pause. I think the next thing you'll have is some staff roundtables, very important staff roundtables next week on implementation phasing, staff roundtables on segregation of cleared swaps, maybe some others. But as we are able to move towards some final rules in the next couple or several months, we'll be doing as we're always do, is posting the public and putting out Federal Register releases for meetings like this to do our business in public and do final rules. With that, if there's not further Commission business, I'd entertain a motion to adjourn the meeting.
So moved.
Second.
All in favor?
Aye.
Aye.
Any opposed? It appears unanimous. I thank you all. I thank all the staff. I thank the public for being with us for these 14 meetings and being with us on all their comments going forward.